Okay, so let me go ahead and call the case. This is 23 CF 475 State versus Josie Dikeman.
Matthew Torbinson and Emily Root appear for the state. Also present at state's counsel table is Investigative Sergeant Rich Ammonson. Good morning, Your Honor.
Morning.
Morning, Judge. Ms. Dikeman appears in person with her attorneys Chris Zacher and Dave Bowles. Also present is paralegal Emily Sanchez.
Couple issues to talk about this morning. One is the issue of the photos. The court has had an opportunity. Did you want to mark this as an exhibit, or we will at some point?
I have them printed. If I can have that marked as well, Your Honor.
Okay. The court has had an opportunity to review the exhibits. I also went back over the stipulation. One thing, there isn't a minor error in the stipulation. I don't know if you caught it. It says on the page 2, it talks about October 23rd, 2023. I think that's supposed to be, yeah. Well, also there's rescheduled to October 30th, 2102. So that's, I don't think either of those dates are right. So just so you know, there's just some errors if you want to just correct them.
I think those are typographical. We can correct those.
Yeah, I didn't notice that until last night when I reviewed it. But the issue, and I know you made your arguments yesterday about it, so I'm going to just make a decision on these. The issue I see is that the 2011 and the issue that she gets in, that Ms. Dikeman ends up having the conviction from, is really from the 2013 situation. I think the 2011 situation is explained, and these pictures are from 2011, when HT was very young. It says 21 months old at the time. The problem I see is there's I mean, I sort of understand if there was testimony that you might show these, but in the context of the stipulation, it's sort of it doesn't, I don't know how you actually bring them in that makes sense. I also think they are I mean, they're not extreme photos in the sense that you're looking at something like we saw earlier in this trial, but they still are, bruising, et cetera, that should be able to have explanation to. And I think if they're presented, the issue I see is, well, how does one cross-examine on them if you don't have the records for them? And I think that creates another problem. So I think they're prejudicial, but also I think it has a little bit of a problem of how they get presented, and how the fact that the defense doesn't have any records from that period, which is one reason why that it's part in the stipulation that says at the very bottom, of the stipulation, which is that evidence from the 2011-2013 investigations have been destroyed pursuant to the police agency data retention policies. Evidence from 2013 was destroyed following Ms. Dikeman's conviction. The records were not destroyed until Ms. Dikeman's time to appeal for her 2013 conviction had passed. Deleted evidence includes photos, recorded interviews, police reports, and may have included facts helpful to Ms. Dikeman's defense in this case. Regarding the evidence from 2011, you may infer that the evidence was deleted would have been favorable to Ms. Dikeman. Problem I see is this is evidence from 2011, and we don't have the evidence from 2011 we don't have the full evidence from 2011. So I think it creates a problem of fairness. I also think this inference gets sort of countered by the photos. So I think there's an explanation within the stipulation. Given those limitations, I'm not going to allow the state to use those photos. So that's one issue. Was there another, anything else to this morning that we needed to resolve?
Judge, one housekeeping matter. There was an exhibit that was marked after court had adjourned for the evening.
That's right.
it was a transcript for the DAR rule. I for that. Yeah, 261. We'd offer 261.
265. And that's the transcript of the clip?
Dr. Peterson's interview.
Dr. Peterson's interview, okay. Any comment on that from the state?
No, I think we presented Dr. Peterson's interview, so we have no objection to that.
It's of the phone conversation between.
Oh, okay.
Okay.
Yeah, let's.
Wait, did you introduce?
We got a copy of it from them and we
Okay.
introduced it.
Okay.
Okay.
Okay, that's what was confusing me. So this is the phone call from
Mayo,
There's a
Mayo
911
staff.
the Mayo staff phone call. Okay.
Your Honor, we also do have a pending motion, the motion in limine addressing Dr. Glowaki's testimony.
Oh, that's right. Why don't you reiterate what the motion on the doctor's testimony?
Well, the motion cites a comment made in Dr. Glowaki's interview with law enforcement regarding a premonition she expressed at the time to other staff, indicating that she was concerned that if the patient returned, it would be deceased. I indicated many of the reasons why that should not be touched in any way on her examination. Certainly, it's essentially expert testimony, essentially, that she formed this impression that this occurred and was likely to produce death. And she's not a noticed expert. She's not qualified to make that assessment in any way. And that assessment is not based on her clinical observations. This was a femur injury. So this wasn't anything other than essentially propensity and expert testimony that has not been noticed and is outside the scope of her role in this case. She's a fact witness, essentially.
Yeah, and now I'm remembering which one it is. There may have been a number of motions in limine in this case, but what's the state's response to that?
This is really easy. I don't plan to go into it.
Okay. All right. Yeah, if you could just inform her to avoid that.
Yeah. If I can go out and talk to her before, just to make sure that she knows and is aware of that, I would appreciate that, Your Honor.
Yeah, and I'll give you an opportunity to go talk to her about that. One other issue, I would ask the defense if you're intending to call Ted Colkine, need to know the date. There's a bit of a conflict with court personnel that we need to have a different person be here.
Sure. Wednesday or Thursday would be my guess.
All right, if you can let us know by Monday, what day? Because the issue is that we have to get somebody to be available on that day. So we don't want there to be any inference of anything.
I understand that. And I understand the rationale here.
Okay. And if you need further explanation from the state, let me know and I can explain that.
I don't.
Okay, anything further from the state?
Just procedurally with our second witness, Ms. Root is going to be handling the second witness that we're going to present today. She has requested that she not have to use the podium but question from the table because of the number of exhibits we're going to have. I think it's going to speed things along and help the procedure if that takes place.
Yeah, I have no problem with that. Just make sure the microphone's pointing at you, that's all.
Absolutely, Judge. Thank you.
Yeah.
And then I'm planning on asking that the other act stipulation be read to the jury after the first witness. I know that the court has the limiting instruction that the court plans to also present. My only request is that the limiting instruction states identity, but I think the court's original ruling was identity and method of operation. So I'd ask that method of operation also be added to the purposes for which the jury can consider the other act's evidence.
Yeah, I started going back through this. It's the conflict between identity and method of operation being somewhat similar. And so if you want me to say method of operation, I would include it in the same definition as identity. Does that make sense?
I would just ask that after you put identity, you say and method of operation.
Okay.
Because I like to use method of operation when I discuss other acts evidence. That would be my only request, Your Honor.
Judge, just so it's clear, method of operation is a route of proving identity. Just so it's clear in the stipulation that it's just one way of proving identity, not something completely separate.
Right, and that's why when people say, when they bring motions for other acts and say identity and modus operandi, it gets very confusing because really modus operandi is a way to get to identity.
My main concern is the jury's going to be given that instruction. If I refer to it as method of operation in my closing argument and they say, well, I can only consider this for identity, I don't want it to be confusing to them. So I will elaborate, I will explain it during my closing. It's just phrasing that I prefer, and I'm just asking that it be included.
But it is constrained to proving identity.
Okay, I'll tell you what. I'm just going to leave it as is. I'm sorry about that. If you could explain it during your at some point during your closing. The reason is it's not even in the standard jury instructions in 275 about how to put that in here. If we're talking about it in 275, they talk about identity. They give a definition for identity. I think that's what I used in the end. So I'm just going to stick to 275.
I understand the court's ruling. In my brief and in the case law I provided, it explicitly talks about method of operation, and the court ruled that that language was okay or one of the methods. And so just for the record, that's why I'm asking for it.
Yeah, I understand. It's just that the standard jury instruction doesn't have that caveat in it, and so I'm sticking to what the jury instruction committee has suggested as the right instruction. And I've only added a little bit that the defense added on the issue of propensity-free reasoning. That's the only thing I've added, really.
I'm really just asking for 3 words to be added for the state.
I know, but I don't know how to say that without stumbling over it. And then there's a question of would I put identity or method of operation or and method of operation? And then the question would be, well, what's the definition of method of operation? I think it creates confusion, to be honest.
Would the court consider putting identity, i.e., method of operation, which it just explains that method of operation is a form of proving identity?
So this is what it says. Definition. The evidence received in this on the issue of identity is the prior conduct of the defendant so similar to the offense charged that it tends to identify the defendant as the one who had committed the offense charged. It doesn't use the term method of operation, but it's essentially that definition. So okay. I'm going to just use this. And that's, you want me to read, I was going to read that after you talk about the other acts.
Do you want me to read the stipulation in the record, or does the court want to read it?
I can read it. It's, I do need the new dates then. Is that October? I assume October 23rd, 23rd. I'm not sure what date that is. 2013?
I believe that would be accurate, 2013.
Yes, and I would stipulate that it was a long stipulation. And, 20. Yeah, I'm told. Yeah, it'd be 2012. Is our understanding.
Yeah, it would make. Okay, that would make sense. October 23rd, 2012 to October 30th, 2012. That would make sense because of, even though it says 2102, but that would be just an inverse of 2 letters, or 2 numbers. Okay, I'll tell you what. I'll read it, do my best. It's a long one. If I miss, I'll do it, and then we'll do if something I stumbled over. We'll take a break at some point, and then I might have to repeat it if it's a horrible stumble. And I'm just saying that up front because it is relatively wordy here, and I don't want to misstate something. So I'll be very careful and read it out loud. So
because it's so long, would the court consider giving each jury member a copy of it to read along with? It is stipulated facts. And then they could be collected immediately after.
You know what? I think that's appropriate. Any objection to that?
No, I think that's consistent with the rules of evidence. So.
I think that's appropriate. Why don't we do that? So we need a clean copy.
Yeah, was there a second date where I transposed a number? I think the court indicated 2.
Yeah, it's in the same line though.
Okay.
Yeah.
Okay.
It's in the same line. It's that second dashed line in right after doctor appointments.
Sure. In my defense, I think we went through at least a dozen revisions between the two of us. So.
Attorney Zachar is 100% correct. We worked diligently on that.
Yeah. No, I appreciate it. I appreciate it. This is not an easy stipulation. I didn't find anything else other than that.
Yeah, I consent to the court correcting as indicated, or we can certainly pull it up and make a quick
The only
revision.
thing is if we're going to hand it to him, I need a corrected copy so we can print it off and do that. So we have a little time today. Hopefully by maybe over noon or somebody can correct it and print it off.
We're hoping to do it after the doctor testifies,
Oh.
but maybe we can take a break after her testimony and resolve the issue.
Okay, okay. Or if either one of you want to correct it and send it to Christina and she can print it out.
I'll see if Ms. Sanchez can pull that up and we can send it out to everyone.
And actually, would you do me a favor and also send it to me?
Sure.
And the reason is I might put it in bigger format, so when I'm reading it, it's, I don't know if you've all caught this, but I have a little bit of dyslexia, and so I need to be able to follow it a little bit closer than most other people.
Sure.
Especially if it's stuff I don't usually read. So that's why I say these things. So having said that, anything else we need to talk about then?
No.
No, Your Honor, I know the state needs a minute to talk to Dr. Glowaki here, so.
Right. Why don't you go talk to, once you come in, we'll bring the jury in.
Okay.
Oh, wait, there's one more issue, Mr. Robertson. I forgot about this issue.
Do you want me to explain it to them?
No, why don't I explain it?
Okay. No, it's the blonde lady. Ford, I think it's. Okay. Yeah.
Yeah, okay, all right. Forgot about this issue, and I'm glad you came in, Kevin, and told me about this. One of the jurors, after Ms. Ford testified, realized that that juror worked with Ms. Ford's husband. I think it was a different last name that was presented, so I'm not surprised they didn't know it. We could bring that juror in and do a voir dire if there was a concern about their, how they are on the jury, or we can, if there's no concern, we can proceed. Obviously, this person, I don't know what the relationship, but probably is more appropriate to do some type of questioning just to make sure we understand. Or I could ask, no, I think that's probably the best way. I've done it that way in the past, unless the state has different feelings about that.
The only thing I was thinking, Your Honor, is that if she disclosed it to someone, I think that's out of an abundance of caution. And I think if it could be communicated back to her by someone directly from the court staff saying, does that affect your ability to be fair and impartial? And if she responded no to that individual and we made a record of it, I think that would be sufficient for me without drawing enough attention to it.
Would there be, could I do that? What I would do it is I'd walk out in the hallway and have that person pulled out, just say, ask them, can they be fair and impartial, come back and report. But I'd have to have permission from both parties.
I would trust Your Honor to do that.
And I guess I would ask, was it communicated that she would struggle to be fair and impartial as part of this, or was it just a disclosure of, I realized.
Yeah, but did you just, they just said, they just wanted you to know it was the relationship, right? Yeah. But they didn't say anything about it.
Judge, I trust the court if the court wants to have a chat with the juror and just see what her views are after that.
Yeah, I actually don't even know if it's a her or him, to be honest.
My apologies.
Yeah. So why don't I do that while you go talk to the doctor, and then I'll come back in and I'll let you know.
Okay, thank you.
Thank you.
But you can just. Sorry about that. Oh. Are pretty processes.
These numbers.
Record. So I did talk to a juror number 2201. That's the person. JH. The at work, different department, they cross paths every once in a while. Outside of that, they don't have any social. He said he could be fair and partial. That was basically the conversation. Other than the fact I don't know anybody's name. So I had to figure that out. But anything else? Is there any concern about that?
None.
Any concern?
No, I trust the court's assessment, and if the court believes that the juror is still fit to serve, then I would agree.
Yeah, I think he's fit to serve. He said he doesn't even know them. He realized it just at that moment she said her name, what it was, who she was. So, okay, having said that, have you talked to the doctor?
I have.
Okay, let's bring the jury in, and then we'll bring your witness in. All right, everybody may be seated. Good morning, everyone. Sorry we're running a little late this morning, but we're ready to the last day of the state's evidence, I'm hoping. Go ahead, call your next witness.
State calls Allison Glowaki to the stand.
All right. Let's swear in right over here. Dr. Glowaki.
Raise your right hand. You do solemnly swear the testimony you give in this matter shall be the truth, the whole truth, and nothing but the truth.
Yes.
If you need anything, just go ahead and grab water. And you can pull the microphone. There you go.
Thank you.
Good morning.
Good morning.
Can you please state and spell your name for the court record?
Yes, it's Allison Neal, and the last name is Glowaki, Glowaki. First name is spelled Alison.
You started opening that bottle of water and I interrupted you, so if you want to take a drink, go ahead, and I will wait to ask you questions. How are you employed?
I am employed at Amplify by Gunderson, we go by now, and I'm a pediatric hospitalist there.
What does it mean to be a pediatric hospitalist?
It means that I take care of kids who are in the hospital, so kids who are sick in the hospital, and then we also take care of healthy newborns in the hospital.
Kids and healthy newborns?
Mm-hmm.
You're a doctor.
I am.
And a hospitalist is a special title within a medical facility, is that correct?
Yeah, that's correct. So it used to be that clinic doctors would take care of people in the hospital also, and then that's become more compartmentalized, and so you'll have now doctors who work primarily in the clinic and doctors who work only in the hospital. So I'm a doctor who works only in the hospital.
Only in the hospital, with pediatric patients.
Yes.
How long have you worked as a doctor?
So I completed medical school in 2019, and I completed my pediatric residency in 2022, and I've been at Gunderson since then.
Can you describe what a pediatric residency is?
Yeah, so it's 3 years of training, and we spend time working. I went to the University of Minnesota, and so our residency program has a lot of time inpatient, and so that means in the hospital taking care of patients. and then learning kind of from the various subspecialties. And so that means, doctors who are specialized in cardiology, so the heart, pulmonology, the lungs, nephrology, the kidneys, hematology. And so over those 3 years, kind of month to month, we go through different rotations before we complete our residency. And it's all working in pediatrics.
As the pediatric hospitalist with Gunderson, I want to direct your attention to January 16th of 2023. Were you working in your capacity with the hospital on that day?
I was.
Did you have contact with a child by the name of Alexavier Pedrin?
I did.
How did that come about?
So I got a call. I actually got a page. We still use pagers. And so I got a page from a provider at Mayo, and they wanted to admit a patient to us. That patient was Alexavier Pedrin. And so I called that provider, and they shared with me the story about what had been going on and that he had this broken femur and he needed orthopedic surgery. And so they asked me to admit him to our hospital.
So you had contact with someone from Mayo, and they provided you the injury that Alexavier had, correct?
Yes, it was a nurse practitioner at Mayo that I spoke with.
Did they also provide you with the medical history that they gathered at Mayo?
They did.
Did the individual that you talked to share their concerns with regards to Alexavier as well?
They did. So they told me about the kind of injury that he had, this femur fracture, but that on the x-ray there was a concern about a healing fracture. And then they told me that they had concerns after talking with caregivers that this could be abuse. They felt like some of the injuries didn't make sense with the kind of story that they heard. And so they shared that they had already talked with CPS.
Can you tell us about your first interaction with Alexavier after having all of that information?
Yeah, so I remember that I went to his room. I don't remember exactly what room it was, but I know what hallway it was down. And so I went to his room, and when I walked in, he was with his dad, and I believe they were both in the bed, looking at a tablet together. So that's kind of my first recollection.
What do you remember about Alexavier's physical condition at that point in time?
So he was sitting up in the bed and looked reasonably comfortable, but also had his leg splinted, and so he wasn't moving a whole lot.
What do you remember about the observations you made with Dad and Alexavier together?
It seemed like he was providing him comfort, the way that they were kind of together in the bed and looking at this tablet. It seemed like he was trying to distract him from kind of the reason that they were there, which was the femur fracture. And our initial interactions, I felt like, were pretty friendly as we started talking about things.
At some point, did you gather a medical history from Alexavier?
I did. So I started talking with his dad to kind of gather my medical history, and would also ask Alexavier questions. And then at some point, the defendant also came into the room. And so it was a combination of the three of them that I gathered a history from.
You said the defendant, that would be Josie Dikeman?
Yes.
The defendant was present in the room while you were gathering a medical history from Alexavier?
She did come partway through. So I had introduced myself to them, and then at some point she entered the room.
Did the defendant enter the room before you got to the history of the fracture from Alexavier, how it was suffered?
She did.
Okay. When you were gathering a medical history from Alexavier, were you posing the questions to him, the caretakers, or both?
Both.
Okay. Tell me about the medical history that you gathered.
So I would say that what I was told is that he had suffered this injury at some point. I have to think of the calendar days because I was working a night. It gets confusing when you work nights because you're kind of working 2 days. So I think it would have been the 15th when the injury happened, is what I was told.
Doctor, I apologize. Is there something that would help you review and making sure that the information you're providing us is accurate?
If my, if my.
Report is available?
Yes, that would be helpful. Thank you.
And I'm going to ask you another question before I give you your report.
Yes.
Did you work yesterday?
I did.
How long of a shift did you work yesterday?
I worked from 7 a.m. and I got off at 7 a.m. this morning.
And you're here after working that long shift? Okay.
Thank you.
And what's been marked States Exhibit 119. I'd ask you just to review that. Let me know when you're done reviewing it.
Okay.
Do you recognize what States Exhibit 119 is?
I do.
What is it?
It's my history and physical from admitting Alexavier to the hospital.
I'd ask that States Exhibit 119 be admitted into evidence.
Be received.
Okay. Doctor, I think I interrupted you and you were talking about the medical history that you gathered. What was the medical history that you gathered with Alexavier and the defendant and Derek Pedrin present?
So what I was told is that the morning of the 15th, that Alexavier was at home with his siblings and Josie, and that at some point while he was wearing only a diaper, he was pushed down the basement stairs by his 4-year-old sister. Derek was at work at the time, and Josie didn't see the accident happen, but heard him crying afterwards and found him at the bottom of the stairs. Go ahead.
Oh, I apologize. Go ahead.
I was just going to say, and then I was told that he immediately cried, kind of throughout that day, was okay, was able to bear weight on his leg, went to a birthday party, and it wasn't until the following day, so the 16th, that they sought care.
I want to talk to you briefly about that medical history. So you are seeing Alexavier on January 16th, 2023. You're shaking your head, yes?
Yes.
Okay. And that was a Monday, if you recall?
Yes.
So the information that you were given is that this fall happened one day earlier on the 15th.
You know what? I think I had that wrong. So I think I forgot that this was a Monday. So I was told the injury happened on the Saturday.
Saturday? That would be the 14th?
Yes.
Okay.
And that the birthday party happened sometime in between there.
Between the 14th and the 15th?
Yes. Yes.
Can you tell us about the dynamics when you are asking the question about the medical history? What did you observe?
So as I mentioned, when I was talking with Derek and Alexavier, I felt like it was pretty friendly. I introduced myself and kind of explained to them what information I would be gathering. And then, like I mentioned, at some point, Josie walked into the room and it felt like the atmosphere in the room changed. So it changed from this, I could easily gather information, to all of the information that I gathered was quite defensive.
Did who was providing the information change?
It did shift from obviously when it was just Derek and Alexavier. I would say the majority of the information was coming from Derek. Alexavier was giving some information. And then when Josie entered the room, it was primarily her answering the questions.
I think you told us at the beginning that before the defendant entered the room, you were basically introducing yourself and your role. Is that fair?
Yes.
You really hadn't started gathering the history?
I hadn't gathered a lot of history yet.
When you were gathering the history, did you notice anything with regards to what Alexavier would do before he would answer any questions?
I do remember, I always make an effort to ask a child kind of their impression of what's going on, and depending on the age, I may or may not get an answer. But when I did ask him, how did this happen? He said, I fell down the stairs. At that point, I already had information from Josie that this 4-year-old sister may have been involved in that. And so I asked him about, and your sister was there. And he looked kind of confused for a second and said, huh? And then he looked to Josie before answering that question.
That's something you recall vividly?
I do.
Is there anything else about the dynamics of the medical history that you gathered that you think is important for us to know?
No, I would say that aspect of kind of the defensiveness of the information that I was gathering stuck out to me, because I don't often have people right alongside me as I am doing a physical exam, but that is where Josie was as I was doing my examination of him.
Can you describe that to us?
Yeah, so a lot of the time, parents will comfort the child. I would say that's pretty common. So parents might be in bed with the child as I do an exam. But in this case, I explained to them that I would be doing a full head-to-toe physical exam. And as I was doing it, she was just alongside my shoulder.
From behind you?
Yeah, kind of like next to, behind.
You talked about doing a full body examination of Alexavier. Why is that important in this context?
Because there was a concern about abuse. There are other kind of telltale signs of abuse that we might be looking for, and it's really important to document any injuries that we see.
Such as bruising?
Yes,
Did you document bruising on Alexavier's body?
I did.
Did you take photographs of those
I
bruises?
did.
Would you recognize those photographs if you were to see them in court today?
I would.
All right, I'm going to hand you what's been marked as State's Exhibit 126. I would ask you to review it. Let me know when you're done.
Okay,
Do you recognize what's depicted in State's Exhibit 126?
I do.
What do you see?
So the first photo is a photo of Alexavier's head, and it shows a combination of bruising on his forehead, primarily on the right side, and then some scabbing on the face as well.
I'm going to have you pause for 1 second. I would move 126 into evidence,
No objection?
and I would ask permission to publish as the doctor talks about the injuries.
Without objection.
Okay, Published, received and published.
Doctor, actually, you know what, you keep that one, I've got a copy of the exhibit that we can go through at the same time.
Okay. Switch it.
So is this page 1 that's being displayed in the courtroom of 126?
Yes.
Okay, can you explain to the jury what we see here on page 1?
Yes, so this is a picture of Alexavier's head, and in this photo, he has bruising that's a little bit difficult to recognize in this light, but bruising on the right side of the forehead. And then he has,
I want to see if we can turn the lights down a little bit.
Yeah. There you go.
Ooh. Might be too dark.
maybe in between,
There we go.
so you can appreciate it a little bit more with this lighting, where he has the bruising on the right side of the forehead. And then he has about a 1 centimeter scabbed lesion over the top of that right eyebrow, and another about 1 centimeter scabbed lesion to the lateral side of his eye.
When you're assessing bruising and injuries on a child, are you looking at whether or not the injuries are on multiple different planes?
Yes.
Why is that important to examine?
It's important because it can be telling about like the mechanism of injury. How could this have happened?
Do we have bruising and injuries on multiple different planes in this particular photograph?
We do.
Okay. And does that cause you some concern in the context of your overall analysis of his injuries?
Potentially some, but I think more of the concern comes from kind of the way, how well formed these scabs are in comparison to the timeline of the injuries that was being presented to me.
Explain that to us.
So these scabbed lesions are quite brown and pretty dried at this point. And so to me, they looked like they were older than just 2 days ago. When an injury is new, a scab forms and it has more of a red appearance. Bruises are harder to age. There's not really a good way to do that, so I wouldn't say that I had the same concern about the bruising.
There's no way to accurately date bruising, is that correct?
No.
That can depend on a person's skin pigment color, their own healing rate, things of that nature, correct?
Yes.
The history that you were given was a fall downstairs.
Yes.
Have you heard of a fall downstairs being referred to as a series of short falls?
I have.
And can you explain to the jury what that means?
So it means that at any given point in time during a fall downstairs, you aren't falling from a high distance. So therefore, the impact or energy of that fall isn't considered to be a high impact injury.
Okay, I want to move to the second page of State's Exhibit 26. What do we see on page 2?
So this is continued photographs of his injuries. In this photo, you can see that same injury to the outside of the right eye. And then it's also depicting a slightly larger injury on the right shoulder. And this is also a scabbed lesion that, as you can see, is kind of almost peeling off with healed skin underneath it at this point.
You talked to us already about the concern you had relative to the other scabbed lesions on Alexavier's face. Do you have that same concern with regards to this lesion on his shoulder?
I do. It looks like the 3 of these injuries all happened, at roughly the same time.
Page 3 of 126, what do we see here?
So this is a photo of Alexavier's flank, so kind of the right side of his abdomen toward his back. And this depicts what we call petechiae, which is a certain type of bruising pattern.
Explain that to us.
They're a series of small bruises that sometimes happen and tend to be pretty expansive, so not just in like one area, but might indicate that an entire area had been impacted.
Was there any particular pattern that you could observe in the petechia on his flank?
No.
Page 4, this image is difficult to see, but what injury were you documenting in
So this
page
is
4?
This is a continuation of the petechiae, so this is kind of beneath the diaper that he was wearing. This is showing the right thigh and kind of the buttock region, and there are more petechiae extending down in that direction.
And this is on the right side of Alexavier's body?
Yes.
Page 5.
So in this photo, this was a skin lesion on Alexavier's back, kind of over the hip bone on the right side. And what it looked like is that the outside of it, this was a well-healed lesion, I should add, but the outside of it had kind of a darker color around it, and the inside had kind of a lighter color to it. And so I asked the family if they knew where that would have come from, because it's not a typical pattern that I might see. And what I was told is that it was possible that maybe it was like a rug burn from sliding down some other stairs. I believe the basement stairs didn't have any carpet on them, but there may have been some other stairs that did. And so that was where they thought potentially that would have come from.
So that was the explanation given for that injury.
Yes.
Do you recall who provided that explanation?
Josie.
I believe this is the last. I'm going to turn it sideways. That might help a little bit. What do we see on this image?
So this is bruising on Alexavier's left arm. And you can see that towards the wrist, kind of on the outside of the wrist, there are two bruises in a row next to each other. In the middle of his forearm, there looks like there are three kind of small bruises next to each other in a line going across. And then there's maybe a little bit larger bruising towards the elbow.
You described a line going across relative to the bruises.
Mm-hmm.
Can you elaborate on that for the jury? What pattern are you seeing?
As a pediatrician, we would call that a patterned bruise. And so I think that, you know, we can't say what caused the pattern, but it looks like there was something that together caused that injury. So it doesn't look like it's separate injuries. It looks like it's one thing that caused those injuries.
Now, stairs can be in a linear fashion. Is that fair?
Yeah, it is.
Would you expect this pattern from a linear blow on stairs potentially?
I wouldn't, because of that gap that you can see in between. The most common reason that we might see an injury like that is fingerprint impressions.
So if this were a linear blow to a stair, we would expect that line to continue all the way through.
Exactly.
Did you have an opportunity to also review Alexavier's X-ray imaging of the fracture?
I did.
Would you recognize that if you were to see an image of that in court today?
Yes.
All right. And it was been marked as State's Exhibit 120. What is depicted in State's Exhibit 120?
So this is Alexavier's fracture of his femur, and this is an image that was obtained at Mayo.
So the x-rays were taken at Mayo when he was seen there, and then they were forwarded on so that you could review, is that fair?
Correct.
And as part of your assessment as the hospitalist, the pediatric hospitalist, reviewing and treating Alexavier, this is something you would have reviewed and considered, is that fair?
Yes.
I move State's Exhibit 120 in evidence.
No objection.
Be received.
Permission to publish?
No objection.
Okay. Publish.
Can you explain to the jury what we're seeing on this x-ray image that's being depicted in open court?
So kind of from the top to the bottom, the top bone is his femur, and that's the bone that is broken. And then below that is kind of the knee joint around the middle of that picture. You can see the kneecap towards the right side of the picture, and then the lower leg bones on the bottom half of the picture.
His fracture is what is referred to as a displaced fracture, is that correct?
It is.
What does that mean, and can you explain it to the jury?
Yeah, so it means that the pieces of bone are no longer aligned.
And that's what we can see. The break is the bone is actually moved or pivoted away from the straightness of the femur bone?
Yes.
Okay. When you saw Alexavier, can you describe what, if any, pain you observed him to be in?
Yeah, so when he was sitting still, kind of like I mentioned initially, he seemed to be reasonably comfortable. He wasn't moving the leg a lot. The leg was splinted. But when I did my examination, I would say that it was obvious he was in pain, particularly when the nurse and I rolled him to take those photos of kind of his back and side area.
Was Alexavier given medication to alleviate the pain that he was feeling?
I don't know if he was given medication at Mayo. At our facility, he wasn't given medication until quite a bit later that evening.
Can you explain why that was, if you know?
I don't know.
Okay.
It was offered. It was part of my orders.
It was offered.
Mm-hmm.
Was one of the medications that was eventually administered to Alexavier morphine?
He eventually got oxycodone.
Oxycodone.
Yes. That was sometime, I think it was at 12:47 overnight when he got that medication.
So you documented a medical history for Alexavier. Did you have concerns when you documented that medical history from the caretakers in Alexavier regarding non-accidental trauma?
I did.
You performed a physical assessment of Alexavier from head to toe and documenting the injuries that we went over in court today. Is that correct?
Yes.
Did you have even more concerns for non-accidental trauma when you performed that physical examination of Alexavier?
I did.
And when you reviewed the x-ray imaging and saw the fracture in conjunction with the medical history in this particular case of a short fall downstairs, did you have even more concern for non-accidental trauma in this case?
I did.
Thank you, Doctor. I have no further questions.
Cross?
Thank you. Oh, yes. No, please. Good morning.
Morning.
Doctor, as a pediatric hospitalist, you're a generalist, is that fair to say?
Yes.
And, you know, your job is to provide inpatient care to children, right?
Yes.
And as a hospitalist, as a generalist, you treat a wide range of cases that come in during your shift or call.
Yes.
And when there's a concern about possible abuse, your role is to identify medical issues and report concerns.
Yes.
And your focus, though, is treating and healing children who have health needs, correct?
Yes.
You're not trained as a forensic investigator, fair?
I'm not.
And you're not a pediatric orthopedist, is that fair?
No.
Pediatric orthopedists, those are the doctors who specialize in the musculoskeletal system of children and adolescents.
Mm-hmm.
And they're the experts in diagnosing and treating fractures in children.
Yes, I would say treating, definitely. I can't say diagnosing, but
Well, when it comes to treating fractures in children, you would defer to the pediatric orthopedist,
yes.
Is that fair? And in particular, at the time, you would have deferred to the late Dr. John Peterson.
Yes, and he wasn't in the hospital that evening, so it would have been a different orthopedic physician who I would have talked to.
Yes, and he was the orthopedist on call, my understanding. This is Dr. Baziner,
Mm-hmm.
and he's an adult orthopedist.
Yes.
And but ultimately, there was a consult with Dr. Peterson. You're aware of that.
I am aware of that.
And of course, doctors who treat children always train to put safety first. Fair?
Yes.
So that encourages doctors to be cautious.
Potentially.
And so, I mean, there's a concern of child abuse or neglect. It's always safer to report that concern than to ignore it.
Absolutely.
So concerns may be raised even when abuse is only a possibility. Is that fair?
Yes.
And so you're not trained to make determinations about whether abuse has occurred, and if so, who is responsible. Is that fair?
That's correct.
So you received Alexavier as a transfer from Mayo's on Alaska Clinic. It sounds like you spoke to the nurse practitioner there. That would have been Amanda Hansen.
That sounds correct.
And you received this radiology report that appeared to indicate multiple possible bone fractures in various stages of healing.
Yes.
And you reasonably concluded from that report that Alexavier appeared to have multiple healing fractures.
Yes.
And that's one of the first things you learned about the case. Is that fair?
That's fair.
And multiple fractures in various stages of healing, that's something that appears in the literature. It's a red flag for abuse. Is that fair?
Yes.
The issue being, these are legitimate concerns, right?
Yeah, I would say it's a risk for abuse, absolutely.
The concern being, why would a kid have these unexplained injuries,
Mm-hmm.
essentially?
Mm-hmm.
And in fact, the family was having difficulty explaining some of those other findings other than the fracture. We talk about that separately, but it's fair that they were having trouble explaining these conditions that were believed to be fractures.
Yes.
And for instance, they mentioned a car accident, but you were skeptical because that didn't seem to match up.
I think they mentioned that to Dr. Baziner, not to myself.
Fair. You're aware of that conversation?
Yes,
Right.
because I spoke with him about it.
And so you reached this conclusion about the multiple healing fractures after reading the radiology report from Dr. Wee at Mayo?
I'm not sure who it was.
Okay. But the doctor who provided that report, that was a radiologist.
Yes.
And radiologists, well, first of all, you're aware that he amended his report. Is that true? I'm
aware that after the fact, the report was amended. That wasn't, yeah, I'm aware, yes.
And you're aware that the report acknowledged that what were originally believed to be healing fractures were actually normal developmental conditions?
The report said that it may be consistent with a different explanation, but it also suggested that maybe more imaging should be done.
And Dr. Peterson actually weighed in on this question. Are you aware of that?
No, I'm not.
And we'll get to him in a moment, but well, we can move on. I'll make this more efficient. Doctor, if I showed you a packet of medical records pertaining to the hospital visit in its entirety, I'm not asking you to reread the whole thing, but if I point you to the specific part of the record, would that help you refresh your recollection of the consultation with Dr. Peterson?
Yes, what I would say, I guess I never spoke with Dr. Peterson about this because the way that pediatric hospitalist work is, it's shift work. And so I worked the evening shift. I left that morning at 7 a.m., just like I did today. Dr. Peterson came on that day, and so I never spoke with him about this case.
Sure, and so...
So I don't know what his opinion was.
Sure, but in the course of your professional practice, you rely on entries into the charts to determine what happened before or after you
Sure.
came on. Is that fair?
Sure.
And these are reliable notations that you wouldn't question the veracity of, correct?
Mm-hmm.
Okay. I'm going to hand you this packet. It's labeled Exhibit 266. I'll give you that page site.
Okay.
If you look at the top of that document, you'll see some numbers that are essentially just a way to number the pages. And if you pull up page 374.
Are you using the top numbers?
Yes.
Okay, thank you.
It's Med Rec 374 for the record. Does that remind you or give you the information in terms of his opinion on the issue of those potential healing fractures?
Yes, this looks like it's Dr. Peterson's consultation note.
I can grab that.
Could I? Thank you.
Absolutely. Okay, so in that record, Dr. Peterson discusses these findings that were identified initially in the radiology report.
Mm-hmm.
And there was a potential healing fracture to the inferior ramus.
Yes,
And that's just part of the pelvic bone.
it's part of the hip bone, yes.
Yes, thank you. And then there were findings relating to the tibia. Is that right?
Yes,
And the tibia is just the shin bone.
yeah.
And so according to Dr. Peterson, the finding on the inferior ramus he thought was a likely variant of ossification of ischiopubic synchondrosis and not a healing fracture. Is that fair?
Yes, that's what it says.
And synchondrosis is quite the word, but it essentially means a condition that you can find in children and adolescents having to do with reduced blood flow to the bones.
Yes,
And that can lead to bone necropsy,
yes,
and that's bone death,
yes,
and other developmental or abnormalities in the growth plate.
yes,
And it can also lead to later regrowth,
yes,
which can mimic a healing fracture.
it could.
And so Dr. Peterson wrote in that report that he believed that this was actually not a healing fracture, it was a developmental condition.
Mm-hmm.
Sorry, is that a yes?
Yes.
For the record.
Yes.
I'm not trying to,
Yeah,
it's just, she's writing it down, so. And then the tibia findings, it's my understanding that Dr. Peterson was of the opinion that those were likely osteochondroma.
yes, and that was, I think, consistent with what I would think too.
And that's basically, it's not the same, but it's like a bone spur.
Mm-hmm. Yes,
Thank you. So not a healing fracture,
yes,
a naturally occurring condition.
yes,
So as we've heard, Dr. Peterson concluded that the possible traumatic fracture to the pelvis was a naturally occurring condition. And Dr. Peterson, he's an expert on the clinical application of X-ray findings. Is that right?
yes,
He looks at the X-rays, evaluates the patient, determines what he believes they have, and then determines the treatment plan. Is that right?
yes,
And you would defer to him on those questions. Is that fair?
yes,
So according to Dr. Peterson, the only confirmed fracture was the femur fracture.
Yes.
And are you aware that Dr. Peterson also believed that the femur fracture was consistent with the reported mechanism as a fall down the stairs?
No, I'm not aware of that.
So if Dr. Peterson were to have offered evidence that he was effectively 100% certain that that fracture was not due to abuse, you would not purport to overrule his assessment of that?
Objections, calls for comment on another witness's statements.
It's an if hypothetical.
Okay, I'll let you ask it as a hypothetical.
Do you remember the question?
Can you restate that?
I don't know.
I'm confused by the question.
Well, in terms of, we can get to that. Let me talk to you about this fracture. And so, well, my question was, if he offered testimony that he was effectively 100% certain that that fracture was not a result of abuse, you would not purport to substitute your judgment on that question for Dr. Peterson. Is that fair?
It wouldn't have changed my judgment that I was concerned about abuse based on many other
Certainly.
things.
We're just talking about the femur fracture at this point and the plausibility of how it happened.
So would I have, argued against him? Is that the question?
Right, on just the fracture.
I would have had a conversation with him about that. I wouldn't have just deferred to his judgment based on my interactions and the amount of time that I spent with the patient and the family.
Now, Dr. Glowaki, you did speak with law enforcement about this matter, right?
I did.
And in that conversation, they brought up the doctors whom you refer to, right?
Yes.
And you indicate that you refer these cases out to the orthopedic specialists.
Okay, that sounds correct.
So let's talk about the actual break. You were asked some questions about whether a fall downstairs creates a high impact injury. Is
Yes.
that right? I'm going to need 204. While we're waiting, Doctor, would you agree that the specific characteristics of the household and the staircase at issue could implicate risk factors in terms of increasing or decreasing the risk of high velocity falls or other injuries suffered when falling down a set of stairs?
The environment matters, yes.
So factors specific to that staircase could make a difference, right?
Yes.
So for instance, if a staircase had no railing at the top, that could prevent, railing is something that you can use to slow your fall. Is that fair?
I think it would be hard for a child to use a railing to slow their fall just because of the height of a railing.
Well, it would be something that is possible, correct?
It's possible.
And if the staircase were taller than usual, that could create a higher velocity fall than a shorter staircase. Is that fair?
Yes, that's correct.
And if there were no walls alongside the latter portion of the staircase, that is to say the walls opened up into the bottom of the basement here, that could impact whether or not these injuries would be more at risk of occurring in this instance. Is that right?
It would depend on the situation in that case, but yes.
Well, you wouldn't be able to use friction to sort of slow yourself down because there's no walls. You would have really no ability to slow your fall.
That's true.
And if there were metal supports at the bottom of the staircase, that could create an additional risk of injuries across multiple planes.
Yes.
And if the landing were hard concrete, that could affect the force with which you impact that surface. Is that fair?
For that kind of last series of the fall, yes.
And if a staircase was comprised of smooth treads that didn't have carpeting, that could increase the risk of slipping, right?
Yes.
And, you have it?
Any objection? Oh, this has already been, yeah. Go ahead. You can publish that.
you able to see that okay?
Yeah, I can.
Would it be fair to say that we have a staircase comprised of 15 treads, it appears?
I can only count 11 or so from the photo. It's hard to tell.
There are other angles, but if I were to indicate to you that there were approximately 15 steps,
Okay.
give or take one or two, that's a fairly lengthy staircase. Is that fair?
Seems like a standard staircase, yes.
In the staircase, however, it has no railings at the top. Is that correct?
That is correct.
And no walls along the side at the bottom.
Yep.
And so it opens wide up into the basement there, and you see some metal supports there at the bottom, and then the concrete landing. Is that fair?
Yes.
And I think you see a couple of socks on the staircase. Now, this was not photographed at the time. This was photographed later, but that depicts some of the potential pitfalls that could be on a staircase. Is that right?
Yes.
Would you agree that the staircase did not appear to be particularly safe?
It's not a staircase I would have in my home.
Doesn't seem up to code, does it? And so you would agree that these factors can affect whether or not a high impact fall could result from falling down the stairs?
They can impact the injuries that happen on a fall.
Okay. And including potential injuries along multiple planes and things like that?
Yes, that's correct.
Thank you. So there was some discussion about the nature of Alexavier's femur fracture. You recall that, the fact that it's obviously a complete fracture and looked like a real painful injury.
Yes.
Is that fair? Would you agree that in children, sometimes fractures can begin as non-displaced or incomplete fractures? Is that fair?
That's possible, yes.
Okay. And in that circumstance, it's a fracture that has not completely gone through the bone. Is that okay way to explain that?
Yes.
And those are painful, but they're not as painful as what you saw on that X-ray.
They're not as unstable as what I saw on the X-ray. I can't say that they're not as painful.
But they can bear some weight, at least initially, potentially.
Potentially.
And it could later become a complete fracture, and that would result in the injury that you then saw when you saw Alex at the hospital. Is that fair?
Possible.
So originally non-displaced, incomplete, and then when you saw it, it would have later been, later it would have completed and formed that injury that you saw. Is that a fair assessment?
I would say it's
It's
less
possible.
likely than it is likely, but it's possible.
And that could explain why a child might be able to limp around for a little while and not necessarily realize, well, strike that. You also noticed, you observed bruising and abrasions on Alex. Right.
Yes.
In active children, bruising can be a result of normal activity too.
In certain areas.
And bruising alone may suggest, but it cannot determine what caused an injury.
Yes.
It also cannot determine exactly when it happened.
Yes, I already testified to that.
Confirming your testimony. Thank you. You did notice petechiae on the buttocks,
I did.
and those are very tiny bruises, less than 2 millimeters in size.
Yes.
And they can occur from direct external trauma to the skin or internal trauma to the blood vessels. Is that fair?
That's correct.
And sometimes early bruises can look like petechiae and then develop into larger bruises.
Yes.
And this type of bruising can be caused by a fall or a spanking, for example.
Yes.
And if Alexavier's father, Mr. Pedrin, testified that he would spank Alexavier, that could cause petechiae. Is that right?
Yes, I don't think that petechiae from a spanking would extend up the flank like we saw in those photos.
What I'm saying is it could be caused by spanking,
On the buttocks, yes.
assuming the spanking was limited just to the buttocks.
Yes.
And petechiae could also be caused by a fall onto rough concrete. Is that fair?
It could be caused by a fall.
Such as the sidewalk?
Yes.
Now, you also noticed concern with Alex's elbow, stating it looked like he may have been grabbed forcefully by the arm. I think that was your impression.
Yes, I think that, and I wouldn't say the elbow in particular, those injuries that were lower on the forearm, so the ones that I mentioned next to kind of the outside of the wrist and on the middle of the forearm, looked like patterned bruises that could be concerning for being grabbed.
Yes, you thought it may have been like a handprint.
Yes.
Now, would that be consistent with Alexavier's father, Mr. Pedrin, grabbing Alexavier forcefully by the arm?
It would be consistent with anybody grabbing him forcefully by the arm.
Did you happen to notice any similar bruising on Ms. Dikeman's arm?
Can you say that again?
Did you happen to notice any similar bruising on Ms. Dikeman's arm?
No.
Now, Alexavier was evaluated for dehydration and potential dehydration and malnourishment. Is that fair?
Yes, that's correct.
And dehydration can sometimes be a concern in children, right?
Yes.
It can be caused by normal illness or routine factors, right?
Yes.
But it can also, in some cases, suggest neglect, right?
Yes.
And initially, there was a concern that Alexavier might be dehydrated based on his urine test. Is that correct?
Can I look at the urine test?
Yes,
Okay.
if you need to. It's 376 of that packet.
Okay.
And if, just to save time, you can look, once you're done with 376, you can check 383 for electrolytes and creatinine.
Okay. I would say that the urine test wasn't overly concerning for dehydration.
Sure, he had
The only
he was
number
slightly
that,
over-concentrated.
yes, exactly. The concentration was a little bit high, but other things that we look for dehydration, for instance, ketones, were not present.
Right. And that was your colleague, Dr. DeSoria's impression as well,
Okay.
correct? Maybe you didn't talk to her.
I
but
did not talk
she's
to
your
her about that.
replacement, is that right? Or
But she worked that day.
okay.
Yes.
Don't talk over each other, okay?
And so I'm sorry if I missed your answer, but you would agree that the test showed that Alexavier was not chronically dehydrated?
Yes.
And you also, there was, so the initial concern of, it was a minor concern. It turned out not to be founded, correct, about the dehydration.
Yes.
And you also ruled out malnourishment as a significant concern, fair?
Yes, when I saw him that evening, I always have kind of a review of the growth chart, and so I looked at his growth chart and didn't have any concerns.
Yeah, his growth curves were normal, right?
Yes.
So his overall physical development was generally normal.
Yeah, I think the only other kind of like chronic concern that I noted is that he had dental caries, so that was the only other thing.
Sure. So let's move on and talk about your interactions with the family.
Okay.
You testified that there was a shift in the interaction when Josie entered the room.
Yes.
She was questioning you.
Yes.
She was writing things down.
Yes.
She wanted to know what you were doing.
Yes.
I think at one point you felt, is this a threat? You just moved into town. It felt a little threatening to you in that moment.
I would agree.
And you knew at the time that the family had a history with CPS.
I did.
And it's common for parents to feel defensive at the thought of their children being taken away. Is that fair?
Yes.
And as a busy hospitalist, dealing with difficult family members can be a source of real frustration. Is that fair?
I think it's actually one of the aspects of my job that I enjoy as kind of a challenge.
So it hasn't been your experience that in this day and age, when there's lots of information available on the World Wide Web, and folks often, try to educate themselves so that they can be advocates for themselves or for their families, that you get folks perhaps questioning your judgment more often than you might have in an earlier time when that wasn't the case.
I think that's true that that happens, but I also think of it as an opportunity for our profession to be good educators.
Fair enough. As you previously testified, there is no way a physician in your position can tell just by how a parent reacts whether or not they are responsible for child abuse. Fair?
That's true.
And just because Mr. Pedrin, Alexavier's father, appeared more attentive, you could not rule him out as a source of the external injuries you observed. Fair?
If he had been present in the home, that's true.
And you don't know when those occurred. You didn't perform a caregiver-specific analysis as to access to the child and things like that, correct?
Well, Josie told me when the femur fracture happened that she was the only adult present in the home. So then I wouldn't think that.
We're talking about aside from that,
Okay.
just the external injuries.
Like
you
the
observed.
other
Yes.
injuries?
Yes.
I mean, what they told me is those injuries happened at the time of the femur fracture. So if he wasn't home at that time, I don't see how those could have been caused by him.
Now, would you agree that abusers can turn on the charm when they need to?
Yes.
And your impression was that Alexavier appeared dependent on Josie?
Yes.
But it's not terribly uncommon for a 6-year-old to be dependent on their parent, is that right?
Yeah, I think that's true.
And when assessing whether a parent is acting differently than you might expect, would you agree that it's important to understand the parent's basic cognitive function?
I think it's a consideration, yes.
And did you happen to ever ask Ms. Dikeman if she had any medical condition that would make her appear to have a flat affect or appearance of being combative?
She offered that she had a traumatic brain injury.
And did she offer to you that she's, in fact, 100% disabled because of the multiple traumatic brain injuries?
I don't remember if she used that language.
But that's certainly an important contextual factor, is that right?
I think, yes.
And were you aware that one of these brain injuries was inflicted by Alexavier's father in the act of domestic violence?
Objection, it's irrelevant for her assessment.
It's the same.
Were you aware that there was ongoing domestic abuse in the household by Mr. Pedrin against Ms. Dikeman at the time of this visit?
It's irrelevant for her assessment.
This was actually, there was reference in the medical records. This was something that she considered in her assessment.
I'm going to overrule that. There was questions about Ms. Dikeman's reaction. Go ahead.
Were you aware that there was ongoing domestic abuse in the household by Mr. Pedrin against Ms. Dikeman at the time of the hospital visit?
I actually wasn't aware that there was domestic violence between them. I had been made aware by them of other kind of abuse concerns related to the children, and so CPS involvement related to that.
And would you agree that survivors of domestic violence may not be willing to talk about their experiences to medical providers?
I'm not sure I understand. Like, she wasn't my patient, so I'm not sure I understand why that.
Victims of abuse, though, they can be not forthcoming about what's going on in the home. Is that fair?
Yes, so I think like Alexavier in that case might not be forthcoming about abuse. That's correct.
Well, and in many examinations, it's normal to ask patients if they feel safe at home. Is that right?
Yes.
And did you happen to ever ask Ms. Dikeman if she felt safe at home?
She wasn't my patient.
Right, but we're talking about the household dynamic here, right? And different
That would not be standard to ask caregivers if they felt safe at home independently.
Okay. So back to some of these risk factors. If Mr. Pedrin had testified that he had strangled Josie repeatedly throughout the course of their relationship, would this have been important information for you to know?
Objection, it's irrelevant.
We're talking about Josie's forthcoming, her response to trauma and other things. and crisis.
Yeah, overruled on the basis that the state has brought out Ms. Dikeman's reaction to the doctor at the time of the evaluation. There should be a question of whether the doctor understood that, what the basis of the reaction. Go ahead.
Thank you. Doctor, if Mr. Pedrin testified that he had strangled Josie repeatedly throughout the course of their relationship, would this have been important information to consider?
I don't think so.
And if Mr. Pedrin testified that he had threatened to kill Josie numerous times, would that have been important information for you to know?
I don't see how it would have changed my assessment.
Is there a right way or a wrong way to be a victim of abuse?
No.
Objections here relevant.
I'm going to sustain this. Move on.
Okay. Doctor, when Alexavier arrived, you were understandably concerned that this could be a case of child abuse. Is that fair?
Yes.
And you consulted with a child abuse specialist at Mayo.
Yes.
And together, you developed a series of lab tests to look for additional evidence of injury.
Yes.
And those tests included screening for possible internal injuries to organs like the liver and kidneys.
Yes.
At the time those tests were ordered, you believed it was possible they would reveal additional injuries consistent with abuse rather than an accident. Is that fair?
Yes.
For the lab testing, it did not reveal evidence of internal injuries, correct?
Yes.
Nothing in those lab results jumped off the page as concerning to you.
No.
And by the next day, the orthopedic surgeon believed that the possible healing fractures represented normal variants in a child rather than prior fractures. Is that right?
That's what we saw in his consultation.
And after Josie took Alexavier to his follow-up appointment, you told investigators you thought perhaps you had the wrong impression of the situation. Is that fair? Did you
That
say
is
that?
something that I said during my interview with them.
Thank you.
Yeah.
Right, redirect.
That was only a portion of what you said during the interview, correct?
That is.
He asked you just one very specific sentence. He didn't ask you to provide everything that you said to the investigators?
That's correct.
Did you share other concerns relative to this case with the investigators that defense counsel did not ask you about?
Yes.
Okay, they just asked you about one sentence of an interview that you had with law enforcement, not the entirety of that interview, correct?
Yes.
Because one sentence helps them.
Your Honor, this is an argumentative leading.
Sustain.
Made my point.
Well,
We would strike that.
it is struck because this was leading and argumentative. The entire questioning is struck. You're to disregard it. Go ahead.
You were asked about lab tests, correct?
Objection. Leading.
That's
That's foundational.
Go ahead.
foundational. Go ahead.
You were asked about lab tests, correct?
Yes.
Lab tests can be normal for a child that's being abused.
Yes.
Just because lab tests come back normal does not mean a child's being abused. Correct?
Does not mean a child is not being abused. Yes, that's correct.
That's not the best question. I apologize about that. You were asked about whether or not you explored any domestic violence with regards to the defendant, correct?
Yes.
And you said multiple times, who was your patient in this case?
Alexavier.
Did the defendant appear to have any problem sharing information with you when you were getting the family history?
She shared information pretty readily, I would say.
Did she share most of the information with you? In terms of who was giving you information about the medical history,
Yes.
Alexavier, Derek Pedrin, or the defendant, who was most of
I
the
got
information
most of the information from Josie.
from the defendant?
Yes.
Would you say she was controlling the conversation?
I would.
Overruled.
You would? I just want to make sure I got your answer.
Yes,
right.
I would.
You would. You have Exhibit 266 in front of you.
I do.
You were asked questions about the orthopedist's opinion. I believe it's on page 374.
Yes.
An orthopedist does what?
They primarily perform surgeries related to bones.
And their specialization is specific to that, is that correct?
That's correct.
The opinion that is contained by the orthopedist in this case, does he limit his opinion to the only injury that he's considering? On page 374?
Can you ask that again? I don't
Yes.
understand the question.
The orthopedist's name is what?
Dr. Peterson.
Dr. Peterson. And Dr. Peterson, in giving his opinion on his concern level for non-accidental trauma in this case, is he only talking about the femur fracture?
He actually really doesn't have an assessment in here related to whether this was non-accidental trauma that I see. Maybe I missed part of.
Dr. Peterson would not be considering the bruising, correct?
Objection leading.
Given what, for expediency, go ahead.
He would not be considering the bruising, correct?
Yes, I think his exam is clear that he looked at him generally. He did a musculoskeletal exam, so felt his legs and felt that his pulses were there, looked at his splint, and performed no other exams. So I would say that he wasn't basing his decisions off of a skin exam or other parts of the assessment that I made.
I'm going to have you review page, it's 375 is the top number. Do you see the note from Dr. Peterson there?
Yes, I do now.
Okay, Dr. Peterson in that note is only referencing the fracture, correct?
That's correct.
And this would be the femur fracture.
Yes.
He is not considering the bruising injuries to the child when he's making an assessment about non-accidental trauma, correct?
Yes,
He's also not considering the medical history that you had.
exactly.
Those are two additional pieces of information you had and you considered that Dr. Peterson did not.
Yes.
You were asked some questions about speculative causes of the injuries, like spanking. You had no history whatsoever of spanking, correct?
That's correct.
Are you aware that Dr. Peterson offered an opinion about child neglect in this case?
No.
Objection, no, this is outside the scope.
They asked about Dr. Peterson and his opinions of this witness.
Yeah, overruled.
Are you aware that Dr. Peterson said that this fracture would have been very painful and that a delay in seeking care would be consistent with neglect in his mind?
I'm not aware of that. I would agree with that.
You would agree with that opinion?
Yes. And the delay in seeking care also raises concern when you talk about kind of
Not
risks.
responsive, I object.
Sustained.
Does a delay in seeking care raise a red flag with regards to child maltreatment and non-accidental trauma?
Objection, yes, this is unknown as expert opinion.
Sustained. Let's move on.
Given everything that you know about this case and Alexavier Pedrin, do your concerns regarding non-accidental trauma, given the totality of the picture you
Objection,
saw?
this is expert opinion again.
She's already talked about this.
Go ahead.
Given the femur fracture that you saw, the bruising and abrasions on different planes and different locations of his body, the time frame that you were given and the medical history that you were given, do all of those contribute to your concern for non-accidental trauma in this case?
Yes.
Last question, doctor. You talked about the fall down the stairs being a low force short falls. Is that correct?
Yes.
a child is forcefully shoved by an adult downstairs, that creates a lot more force, doesn't it?
Objection.
Overruled.
That creates a lot more force, doesn't it?
Yes, being forcefully shoved creates more force.
That changes the dynamics of the fall,
Yes,
and it increases the momentum involved in the fall.
yes.
Thank you, Doctor.
Okay, redirect or recross me.
Briefly. Doctor, you're aware that Dr. Baziner concluded that this could have been caused by a fall down the stairs?
I'm not aware of him saying that. When I spoke with him that evening, he said that there were a lot of red flags in the room, and he shared my concern.
He indicated this would be hard to do, that fracture would be hard to do in an abuse case. You are aware of that?
I'm not aware of that.
Are you aware that Dr. Baziner indicated that it could be, or I'm sorry, Dr. Peterson, forgive me, concluded that it could be evidence of neglect if not treated?
Well, I think the language that was used was a delay in care would be concerning for
Sure.
neglect.
And our questions about the nature of the fracture initially being non-displaced and lined up initially, that those questions go to whether or not the injury initially would have been as aggravated as the injury that you saw. And you would agree with our conversation on that, correct?
Again, I think that weight bearing maybe could be possible, but the pain I would expect to be quite significant.
Sure. Now, you indicated that you were not aware, nobody had indicated spanking to you. Is that fair?
Yes,
So CPS didn't tell you that Mr. Pedrin admitted to them that he spanks Alexavier?
no.
Nothing further. I would move admission of the,
Oh, go ahead. Just finish what? Okay.
Nothing on that.
I would move admission of the exhibit.
We're talking about the
266.
266. Any,
Just for the limited purposes that it was used, I don't think it's.
I mean,
okay,
these are all
I'll tell you
records
what,
that we.
we're going to take a break anyway. Why don't we talk about this during the break? What I'd like to do, ladies and gentlemen, we'll take a break. Let's say 10:30. We have to get some stuff together. Okay. Oh, okay. I didn't see that. Okay. Are they outside? Can you grab those guys? Oh, no. No, just put them right there. Okay. All right, everybody be seated. I think we're done with testimony with you, so you can go get some sleep.
Okay.
All right, take off. You're welcome. Is she relieved from her subpoena?
I don't think we have a subpoena on her.
Okay.
Yes.
Yeah. All right. Enjoy your night. All right. Two things. One, those are the stipulations. We did print them off. I printed off whatever you sent us through the email. So yeah, each of you grab a copy of it, and then the rest are for the jury, I believe. You can just leave them on the. And then and there's an extra one for the court reporter. We only have one extra, one for each.
Gotta share.
Okay. Those are going to the jury. The rest of those go to the jury.
I'm gonna collect them back after we review it. We're all gonna review it real quick.
Oh, okay. Yeah. Go ahead.
I'll just review it, Judge.
Okay. And then the other thing is I just took that and made it 14 font and double spaced it for myself to be able to read, so.
I always do.
And then, there was an issue of the exhibit. I know it's medical records, right?
They are, and they're authentic by stipulation, but in terms of the statements, they're either statements for purposes of medical diagnosis or statements from the treatment providers that have independent indicia of trustworthiness because they're essentially for the same function. So I believe that they should be entered into the record as substantive evidence.
Counsel?
I'm not necessarily objecting to them being admitted. I guess there are only very small portions of 266 that were testified with this doctor, and if there was a request from the jury to see all of 266, I would only want the portions that were testified to be observed, and we can deal with that.
We can
later.
work that out.
Yeah, and, okay, so 266 is received, and then if, usually I don't send those things back to a jury anyway, but,
Figure out what they say.
okay. And then we'll go, if requested, we'll deal with that issue at that point. Okay, anything else we need to talk about before I let you take your break?
I'm seeing one typo that survived here, page 1, fourth paragraph down.
I don't,
Concluded that the discolorations, bruising were consistent with the stair fall. I think the language that we ultimately settled on is the discolorations were consistent with the reported stair fall. Is that correct, Mr. Torbenson?
I'm just trying to find it.
where is it?
Page 1, fourth paragraph down, midway through the paragraph.
Rather than were also was supposed to be the word was?
No, it just reads, the way it reads is concluded that the discolorations, bruising were consistent. I think we intended to say concluded that the discolorations were consistent.
Just remove the word was. Is that what you're saying?
Well, I mean, discolorations, bruising is also confusing there. I think we talked about this where we wanted the term discoloration used because that's how it was described in the report, but.
Okay, so it would say, Dr. James Hogan evaluated Haley's bruising and concluded that the discolorations were consistent with the reported stair fall.
That's my request.
Okay, I have no objection to that. So remove bruising and was.
I mean, if the court just wants to strike that from its copy like that, I just noticed that made it into the.
Well, we could just strike them. Tell you what, let's redo the first page. I don't know if you sent it to me sent it to the court as a, looks like, no, here it is, okay. We can reprint the first page if needed. Why? Is that happening? Hold on a second. All right, so let's correct that one.
And I'm sorry.
Go ahead, might as well.
I think Attorney Zacher and I agreed that the very last sentence would say that you may infer that evidence that was deleted from the 2011 case would have been favorable to Ms. Dikeman.
We did agree on that.
So I would ask that that be added to that last sentence.
Wait, this is page 4?
The very last sentence in the stipulation.
You may infer that the evidence that was deleted would have been favorable to Ms. Dikeman. What did you say it was supposed to say?
You may infer that the evidence that was deleted from 2011 would have been favorable to Ms. Dikeman because the appeal period ran in 2013, so I don't think they get that presumption for 2013.
Okay.
My understanding with the 2013 is that we don't get that presumption because of no contest plea to neglect.
Okay. So looks like we just need to reprint the whole thing.
This is still saving hours of testimony, Judge.
No, I appreciate that. No, I get that. I get just one small tree every day. Actually, we're doing better nowadays. So let me, okay, we'll just get rid of the copies we have, we'll redo it. Just be easier. Anything else, since I'm making the change? Make
My
sure
quick
you-
read through, I don't see any other errors.
If there's anything else, it's on us now.
Okay, right.
If the court needs pronunciation, it's pronounced phalanges.
Phalanges?
Phalanges.
At least there's no ischiopubic or synchron.
Yeah, thank you, thank you. All right, so 10:30, maybe 10:35, the way things is gonna go. All right, thank you. may be seated. Make sure I have cautionary instruction. Okay. All right. Everybody's present. We've given you our newest copy. Hopefully that's good. So when the jury comes in, what the plan is that I'll tell them we have a stipulation to read to them. They actually have a copy of the stipulation on their chairs. Anything we need to talk about before we bring the jury in, just to fully explain, I'll read the stipulation, then I read the cautionary instruction. That's what I'm planning to do. Any concerns from the state?
It just strikes me that we've had the other acts come in for Mr. Pedrin as well, and we have not read a cautionary instruction as to that. I don't know if there's a way to
I mean, I can
address it now as to we've heard evidence regarding other acts involving both Ms. Dikeman and Mr. Pedrin.
the only issue there is, and I will consider it the final part, partially because this is specifically a cautionary instruction because of the defendant and the propensity, the question of you using, this is a very specifically for the defendant. So it might be confusing because obviously propensity evidence is not an issue with a witness per se, necessarily, now that I think about it, but it's obviously a constitutional issue for a defendant in a crime, in a case. So for right now, I think that might be something we can talk about at final jury instruction. Mr. Zacher, Mr. Bowles, any concerns about how we're going to proceed?
Not with the stipulation. I'm looking at some of the tables that the state provided me now.
Okay. All right. So let's bring the jury in, and then we'll do the stipulation, and then you call your next witness. Everybody may be seated. Ladies and gentlemen, the attorneys have come to, the parties have come to a stipulation on some facts and it's on these other acts. We gave you a copy of it simply because it's very long. We are going to take it back and then we can talk about whether it would go back at a later date. But I'm going to read the stipulation to you because that's required to put it on the record. You're welcome to follow along, of course. And then there will be a cautionary instruction about other acts I will give you at the very end. We're not at the end of the trial at all. We're just doing this at this moment. There's one more witness at least from the state. So stipulation on other acts evidence. The parties have stipulated that on July 13th, 2011, 21-year-old Haley Tapscott suffered extensive skull fractures involving the right parietal vault and the right suboccipital area into the posterior fossa. The posterior fossa fracture is slightly depressed and crosses the transverse sinus. In addition to the skull fractures, Haley Tapscott's scalp hemorrhaging, cerebral infraction and traumatic encephalopathy, along with multiple bruises on different areas of the body, of her body. Josie Dikeman called the nurse advisory line after observing.
You said 21-year-old instead of 21-month-old. I don't know if that's important.
Thank you, 21-month-old. That's why I gave it to you to read. And I sometimes skip over things, so excuse me. Josie Dikeman called the nurse advisory line after observing that Haley was lethargic and unable to walk and brought her to Gunderson Health Systems for treatment. Ms. Dikeman reported that Haley had fallen down a staircase at 11:30 a.m. and that the baby gate she and her partner, Dustin Barnes, had previously placed over the stairs had broken and was not installed before the fall. La Crosse police investigator Tony DeLapp walked through the home and did not note any facts inconsistent with Ms. Dikeman's report of the broken baby gate. Ms. Dikeman was the only caregiver home with Haley when she was injured. Haley's injuries were suspicious for non-accidental trauma. Haley was evaluated by multiple physicians while hospitalized. Neurosurgeon Dr. Edison McDaniels examined Haley and reviewed her head CT imaging. On July 13, 2011, at approximately 6 p.m., Dr. McDaniels observed a brownish yellow bruise behind Haley's right ear that looked to him to be older. The parties have agreed that it is impossible to date a bruise to a specific time frame without histological testing. Dr. McDaniels concluded that her injuries were concerning for non-accidental trauma through the mechanism of a reported stair fall could not be ruled out. Pediatric intensive care physician Dr. Karen Richmond evaluated Haley and noted concerns about bruises that appeared to be of different ages and in places that don't seem to be consistent with mechanism of injury. Dr. McDaniels and Dr. Richmond were unwilling to classify Haley's injury as abuse when interviewed by La Crosse police investigator Tony DeLapp on July 14, 2011, and stated that Haley's injuries were also consistent with a fall down a flight of stairs. However, they considered that explanation unlikely. On July 14, 2011, at approximately 7:30 p.m., dermatologist Dr. James Hogan evaluated Haley's bruising and concluded that the discolorations were consistent with the reported stair fall. Dr. Hogan concluded that there were no other abnormal etymologies from the bruising he observed that suggesting a different mechanism of injury from the stair fall. Dr. Richmond consulted child abuse pediatrician Dr. Ann Budzak about Haley's injury. Dr. Budzak ultimately concluded that while a fall downstairs was unlikely, in her opinion, to produce the severity of injuries Haley Tapscott sustained, she could not rule out a fall down the stairs as the cause of Haley's injuries. Dr. Richmond also consulted with pediatrician Dr. Kelly Hodgson-Klein, who regularly evaluated children for non-accidental injury. Dr. Hodgson-Klein also declined to conclude that Haley's injuries were the result of a non-accidental trauma, though Dr. Hodgson-Klein also felt a fall down the stairs was unlikely to produce the severity of injuries sustained by Haley Tapscott. Ms. Dikeman was not convicted of any crime related to Haley's injuries in 2011. On January 17, 2013, 3-year-old Haley Tapscott, date of birth 10/8/2009, was admitted to Gunderson Lutheran Hospital from June of 2012 through January 17, 2013. The primary caretakers for Haley were Haley's father, Dustin Barnes, and Dustin Barnes' girlfriend, Josie Dikeman. Haley was admitted to Gunderson Lutheran for numerous health concerns, including weight loss, hair loss, significant swelling of her left foot, X-ray studies revealed healing fractures to the second, third, and fourth phalanges on Haley's left hand, as well as the distal second and third metacarpals. As to Haley's right hand, the proximal shaft of the third and the fourth phalanges were also noted to have postural changes consistent with healing fractures. One physician pediatrician Ravi Naik believed that Haley's hand x-rays showed fractures and diagnosed her with non-accidental trauma. Another physician, orthopedic surgeon Robert Volz, opined that the x-ray images of Haley's hand demonstrated possible healed or healing fractures, but he did not conclude that the hand x-rays demonstrated definite fractures or constituted evidence of non-accidental trauma. Dr. Volz agreed that Haley's foot injury was concerning for non-accidental trauma. It is unknown how Haley sustained her injuries or whether any injury to Haley's hand occurred while she was in the care of Josie Dikeman and Dustin Barnes or at an earlier time. Neither Haley's caretakers, Josie Dikeman or Dustin Barnes, took Haley to a number of scheduled doctor appointments. Doctor appointments were regularly rescheduled, canceled, or missed as follows. An appointment scheduled for October 2nd, 2012 was rescheduled to October 23rd, 2012. The October 23rd, 2012 appointment was rescheduled to October 30th, 2012. Neither caregiver brought Haley to the October 30th, 2012 appointment. Dustin Barnes canceled an appointment for Haley on December 10th, 2012. On December 19th, 2012, appointment was canceled with a notification that the family had a problem with transportation. Neither caregiver brought Haley to the December 26th, 2012 appointment. Neither caregiver brought Haley to the January 16th, 2013 appointment. Haley attended a doctor appointment at Gunderson with Dr. Head on December 4th, 2012, where Dustin and Josie expressed concerns that Haley's balance and gait and inquired about medical imaging to address it. Haley attended a doctor's appointment at Gunderson with Dr. Ammonson on December 6, 2012. Prior to June of 2012, Josie Dikeman and Dustin Barnes were not the primary caretakers of Haley. During the time frame that Josie Dikeman and Dustin Barnes served as the primary caretakers for Haley Tapscott, i.e., Haley lived with Josie Dikeman and Dustin Barnes, Haley Tapscott went from the 85th percentile in weight to the 6th percentile in weight, and after being hospitalized from January 17, 2013, Haley Tapscott began to gain weight again. On December 6, 2012, medical note by pediatrician Dr. Stephen Manson noted that Haley had recent weight loss, but that Haley had been significantly overweight before moving in with Dustin Barnes and Josie Dikeman. Haley was diagnosed with celiac disease during the January 2013 hospitalization. And it is unclear whether a celiac condition contributed to her weight loss. Dustin Barnes was questioned by Detective Linnea Miller about Haley's eating habits, and Mr. Barnes said that he was restricting her food because of his belief that she was overweight. Since Mr. Barnes has since died and is unavailable to cross-examine, you may give his statement in 2013 whatever weight you believe it deserves. During the time frame of June 12th, 2012, let me try that again. During the time frame of June 2012 through January 17th, 2013, Becky Ellers, Ms. Dikeman's mother, lived in the lower portion of the same residence as Josie Dikeman and Dustin Barnes. In that time frame, Becky Ellers observed Josie Dikeman and Dustin Barnes make Haley sit at the dinner table until Haley finished her food. According to Ms. Ellers, Haley was the only child made to sit at the table until she cleared her plate. Josie Dikeman and Dustin Barnes would also Josie Dikeman and Dustin Barnes would also make Haley sit on the toilet from between 15 to 45 minutes with her hands on her head because Haley had played with materials inside the toilet when her hands were at her side. ZME, who was near the same age as Haley, was not made to sit on the toilet. During these times, Becky Ellers would sometimes see Haley pout and cry. Becky Ellers believes Josie Dikeman treated Haley differently than Josie Dikeman's child at the same age of ZME. Josie Dikeman and Dustin Barnes allowed ZME to stay up late. Haley was not to stay up late. Josie Dikeman and Dustin Barnes allowed ZME to wear pull-up diapers. Haley was not in pull-up diapers and would sometimes be put in timeouts for having accidents in her pants. Josie Dikeman and Dustin Barnes had a potty in Haley's bedroom to stop her from getting up in the middle of the night and falling down the stairs. Child witness GME-R was interviewed and verified that Josie Dikeman and Dustin Barnes would make Haley Tapscott sit at the dinner table for a long period of time or sit on the toilet for an extended amount of time if Haley had an accident. ZME, Josie Dikeman's child at the same age as Haley, was not made to do either by Josie Dikeman or Dustin Barnes. Josie Dikeman and Dustin Barnes also used a baby gate to keep Haley Tapscott inside of her bedroom during the night until morning. Neither Haley Tapscott nor ZME were allowed out of their bedrooms unless Josie Dikeman and Dustin Barnes were awake. GME-R told investigators that Haley needed a gate to keep her in her room because she would crawl over obstacles if the adults were not awake. Child witness GME-R stated that Ms. Dikeman and Mr. Barnes would occasionally have Haley hold out books as a punishment when she had accidents potty training, but clarified that this occurred a long time ago. Before June of 2011, GME-R is the only witness that claims to have seen this punishment. Other children in the home were not made to hold books out in the same way. Paula Hernandez, Dustin Barnes' mother, witnessed Haley Tapscott's left foot days before Haley was admitted to the hospital. Haley was limping and her left foot was swollen and described as huge. When Paula Hernandez asked Josie Dikeman about Haley's foot, she reported that Josie Dikeman said it was fine. Paula Hernandez, who witnessed Josie Dikeman treat Haley Tapscott differently than Josie Dikeman treated ZME. If ZME had an accident, Josie Dikeman would change ZME right away. If Haley had an accident, Josie Dikeman and Dustin Barnes would not immediately change her dirty diapers. Every member of the split-level home where Josie, Dustin, and Haley lived, including Becky Ellers, Eddie McGurr, GME-R, and ZME, told investigators that they did not see Josie Dikeman or Dustin Barnes intentionally harm Haley, but all also expressed concern how Haley was cared for. Dustin Barnes told Detective Miller that he had never witnessed Ms. Dikeman physically harm Haley. As before, since Mr. Barnes is not available for cross-examination, you may give this statement whatever weight you decide to give it. Ms. Dikeman also reported that she did not see Mr. Barnes harm Haley. On September 9, 2013, Josie Dikeman and Dustin Barnes pled guilty to child neglect as a party to a crime related to their actions towards Haley Tapscott. Party to a crime means that the defendant either 1, directly committed the offense, 2, intentionally aided and abetted or assisted someone committing an offense, or 3, were part of a conspiracy to commit the offense. Neither Josie Dikeman nor Dustin Barnes were charged with intentional child abuse for Haley's injury. Disposed evidence. Evidence from the 2011 and 2013 investigations have been destroyed pursuant to the police agency's data retention policies. Evidence from 2013 was destroyed following Ms. Dikeman's conviction. The records were not destroyed until Ms. Dikeman, time to appeal her 2013 conviction, had passed. Deleted evidence includes photographs, recorded interviews, and police reports, and may have included facts helpful to Ms. Dikeman's defense in this case. You may infer from the evidence that was deleted 2011 would have been favorable to Ms. Dikeman. Cautionary instruction. You don't actually have a copy of this. Let me just read this to you. Evidence of other acts or conduct of the defendant. Evidence presented. Evidence has been presented regarding other conduct of Josie Dikeman for which she is not on trial. You may consider this evidence only for a limited purpose and not to conclude that the defendant has bad character or general tendency to commit crime. You must not use this evidence to decide, because the defendant allegedly committed another act at some other time, the defendant must have committed the offense now charged. Specifically, evidence has been presented that the defendant was involved in prior incidents in 2011 and 2013. You find the conduct did occur, you should consider it only for the issue of identity. You may not consider the evidence to conclude the defendant has a certain character or certain character traits, and that the defendant acted in conformity with the trait or character with respect to the offense charged in this case. Definition. The evidence received on the issue of identity is that the prior conduct of the defendant is so similar to the offense charged that it tends to identify the defendant as the one who committed the offense charged. Propensity-free reasoning requirement. To use this evidence properly, your reasoning must be propensity-free. That means you must not reason in this way. Because the defendant committed another act of crime, she probably acted in the same way again. That kind of reasoning is forbidden. You cannot follow this if you cannot follow this propensity-free line of reasoning, you must disregard the other act's evidence entirely. You may consider this evidence only for the purpose I have described, giving it the weight you determine it deserves, and it is not to be used to conclude the defendant is a bad person or for the reason of is guilty of the offense charged. So what we're going to do is collect the stipulations at this point in time. That instruction will be read again later on, just so you know. Are we ready to proceed at this point?
Yes, Your Honor. State will call Investigative Sergeant Rich Ammonson. 2:39.
And one last thing. I do apologize for stumbling over words. The medical terms I am not great with, as you can tell. Go ahead. Oh, yeah, just leave it right there. We'll get to you in a second.
You raise your right hand. Do you solemnly swear the testimony given in this matter shall be the truth, the whole truth, and nothing but the truth?
I do.
Good morning.
Morning.
Will you please state your full name for the record, spelling your last?
It's Richard Ammonson, Amundsen.
And what do you do for work?
I'm an investigative sergeant with the La Crosse County Sheriff's Office.
How long have you been with the sheriff's office?
since 1998.
And how long have you been a investigative sergeant?
Almost 2 years.
So at the beginning of this case, your title was investigator, correct?
Correct, I was a deputy investigator.
Can you just explain for us a little bit about the structure of your department?
Sure. There's 3 different divisions really in the sheriff's office. You've got the jail, and then you have patrol operations and then investigations. I worked in patrol for the start of my career all the way into late 2000, and then I was promoted to deputy investigator. The investigative division is typically has 2 deputy investigators, 2 investigative sergeants, and then a deputy, or I should say investigator administrator. It was a captain. That would have been Captain Siegel, who was elected sheriff, and then he restructured and made that position a lieutenant investigator.
So have there been a lot of changes in your department since this case started?
Yes.
Fair to say, I think besides Lieutenant Williams, you are the only member of the investigative bureau still there from 2013. Everyone else is retired at this point.
Yes, last man standing.
But you have been actively involved in this case since the beginning, correct?
Yes.
Not the only one involved, but been there throughout.
Correct.
You touched a little bit on your previous law experience or law enforcement experience. How long were you in patrol?
I had worked the road as a patrol deputy since 1998 till almost 2020.
And do you have specific experience in investigation of cases involving drugs?
Yes.
Can you explain that for us just briefly?
When I was on patrol, I actually went to, in 2002, I became a DRE, which is a drug recognition expert. It's geared towards impaired driving under 7 different categories of drugs, some legal, some illegal, some prescriptions. In 2006, I became a DRE instructor. That has since lapsed in 2018, so I'm no longer certified as a DRE. I've also attended numerous drug investigation schools throughout my career, and then once in the investigative division, I also attended a 2-week drug investigation school that was put on by the Wisconsin Department of Justice that's specific to both legal and illicit drug investigations.
And you were assigned to assist in the death investigation of Alexavier Pedrin, correct?
Yes.
And when did you receive this assignment?
It would have been the morning of February 11th, 2023. I received a phone call from Lieutenant Williams that there was a child death and he needed me to respond in.
What initial information were you given?
The initial information I was given was that there was a deceased 6-year-old, Alexavier Pedrin, at the address of W5512 County Road OS in the town of Madary, and that I needed to head to the office to work on a search warrant.
That was your first task?
Yes.
Related to this call, were you or are you aware of your department's response time when you're talking about when the call came in to 911 to when officers were on scene?
Yes, the arriving deputies would be Deputy Anderson and Juror got there about within 30 seconds of being dispatched to the call, which is very unusual.
What's the jurisdiction that your agency patrols?
Well, we patrol all of La Crosse County. We try not to do a lot of enforcement in municipalities such as the city of La Crosse or city of Onalaska, but we do have jurisdiction in all those areas. We assist where we need to, but our county is quite large. We may be in Burr Oak, or we may be in the town of Washington, which is quite some distance away. This call would have been in what we call our center patrol, and they could have been as far east as Rockland at the Monroe County line, which would have taken an extended period of time to get there.
Do you remember approximately what time you began your search warrant process?
I began the process when I got to the office. That involves composing a face sheet for the residential search warrant, description of the residence and the items that we wish to look for, document. And then I began, I believe, the oral testimony around 11:40 a.m. with the Honorable Scott Horn and yourself.
So that's something where you provide testimony to a judge?
Correct.
And based on your knowledge of the investigation, would you have been applying for that search warrant approximately the same time that Lieutenant Williams was interviewing Ms. Dikeman?
Yes.
What initial information did you have when you were applying for that search warrant about what deputies on scene had observed?
Right. I had spoken with Deputy Anderson. He gave me the basic layout of what they found, what had occurred upon their arrival, what they found as far as a empty prescription pill bottle. I learned about the previous welfare check from the night before where Derek Pedrin had been arrested. I took all that information.
Were you also aware of Mr. Pedrin's recent domestic history?
I don't know if I was aware of all of the history, but I was aware that he had been on bond for a domestic incident.
And did you include that information in your application and testimony for the search warrant?
Yes.
Were you also aware at that time that Ms. Dikeman had some history related to neglect allegations?
Yes, I was aware of the 2011 and 2013 incidents.
And at that point, you knew that the pill or a pill bottle had been found near the child, correct?
Correct.
Given that, did you limit your scope to just legally prescribed medication at that point?
No, I did not. In any death investigation, especially one like this, you want to have a wide brush to be able to look for things. So the warrant included both legal prescriptions that don't belong to anybody that resides there, illegal drugs. We kept it pretty broad.
You're aware of the possibilities related to what the child could have overdosed on if it was an overdose?
Right. I didn't know what the child overdosed on, so we wanted to be able to collect anything that could possibly be related.
And that search warrant was granted?
Yes.
And what did you do after that?
After the search warrant was granted, I made copies like I'm supposed to, and then I went out to the incident location.
When you arrived, were you briefed by other deputies about what they had observed on scene?
Yes, I was first briefed by Lieutenant Williams. I had some of the details of his interview with Josie Dikeman. I was assigned to go inside and take a look at the scene and start to execute the search warrant. The first thing I did was talk to Deputy Anderson and Juror to get more the layout, where people were positioned, where things were at, once they had arrived on scene, to try to get an overall picture.
And when you are arriving at a scene like this and about to process it, how do you determine what items to photograph and or what items to seize at the location?
Well, you have to take into account of what the call is, what the facts we know at the time. In this case, I did assign Deputy Jar to make sure that he photographed the entire house, the inside, the outside, doors, windows, all of those things. And then once we began the search, I had other assignments for Deputy Anderson and Jar.
Was this the only search warrant that your agency executed on the residence?
No.
A second warrant was done?
Yes, a second residential search warrant was conducted.
When was that done?
That would have been on February 14th of 2023, I believe.
And what was the purpose of that secondary warrant?
That secondary warrant was to have the TRU unit, which is the Wisconsin State Patrol Technical Reconstruction Unit. They have equipment, scanning equipment that can make 3D models of the residence and the interior. It was also to get the micro SD cards out of 2 cameras that were at the residence.
Investigative Sergeant, I'm going to hand you a stack of exhibits, and we'll go through them one by one, okay? First look at Exhibit 81. What is this?
This is a photo of the main level of W5512 County Road OS.
And is it kind of a bird's eye view based on the layout of the home?
Yes,
Was this one of the images that was generated when the TRU was there?
yes,
And does it show a true and accurate reflection of what the operators there and the equipment captured on the 14th of February?
yes.
Your Honor, I'd move Exhibit 81 into evidence and ask that it be published.
Objection.
Received, can be published. 81 is already used. Oh,
Can we do 81A for now, and I'll fix that later, Judge?
sure. Yeah, let's call it 81A.
I apologize.
That's,
You had 81 and 82 already used.
so 82A, or we'll start with 81A and then 82A, and then the rest should be okay, hopefully.
I appreciate it.
Yeah.
Okay, so I'm going to show you what has been newly determined to be Exhibit 81A. And so this is kind of that overall look of the home from the top down, correct?
Correct.
And part of the reason they do or use this technology is because it can be helpful in situations like this where we're having to talk about an event years and years later, correct?
Correct.
This image may not be the most helpful when we're trying to pinpoint things. So.
Correct.
And I jumped the lead here. Based on this, did we create a more general and easy to follow layout that follows the constructs of the layout that was provided through the TRU process?
Yes.
And is this something that was prepared by engineers?
I don't know that they're engineers at the TRE unit, but
I mean the diagram that we prepared for trial.
not quite engineer level, but we tried.
But based on your review of the TRU data, the body cam you've reviewed, and your knowledge of the home through the search warrants you executed, does it fairly and accurately depict kind of the general layout of the home?
It does.
Your Honor, I would move to admit Exhibit 82A and request to publish.
Any objection?
With the understanding that it's not an architectural recreation and that the dimensions are not precise, no objection.
Okay.
Stipulate that it's not even close to that, Your Honor. Thank you.
All right, so 82A will be received, it can be published, understanding it's not architectural level.
Okay. Investigative Sergeant, do you have the laser pointer up there with you?
I do.
From your understanding, can you just point out to the jury the general layout that we're looking at here of the home?
So this is the front door here, where you saw Deputy Jar knocking and was led into the dining room / Josie Dikeman's bedroom. Right about in here is where Alexavier Pedrin was laying. And then there's French doors here that I believe were closed and then later opened. And that leads into like a living room here. There's a TV, a couch where Derek Pedrin had usually slept, and then a buffet kind of table with 4 chairs with some cereal and food on it. As you walk through there, then you enter into the kitchen. The stove is about in here, I believe. And then up in here is where there's a camera that faces down into the kitchen. If you make an immediate left, there's a small hallway. That wall is there, and those are the stairs that go down to the basement. If you come out of the kitchen, this is where the red sheet would be. That sheet is the one that provides a piece of concealment from that room. If you turn left, those are the carpeted stairs that go upstairs to the 2nd story of the residence, where there's some kids' beds and bedrooms up there. To the immediate right here, this is a bathroom with a full tub, toilet, sink. This is just like a little pantry closet right here. Here's Major's bedroom. This is where Major's bed is, you know, to look over this way. And this is the other bedroom that I think they talked about laundry being done and things like that in there.
And then, oh, go ahead, sorry.
This is the back door that you saw in the previous video where Sergeant Kernine and Deputy Paff were at, where they had knocked, because there's a wraparound deck that comes up over this way.
And while you were processing the scene that day, did you have a body cam on?
Yes.
And it was recording?
Yes.
And at some point, did you conduct a walkthrough of the home that visualized most of the areas on all 3 floors?
Yes.
And Your Honor, I'd move for the admission and request to publish 2 separate portions of the body camera, one from Investigative Sergeant's body camera, 2 with time stamps of 1 hour, 0 minutes and 32 seconds to 1 hour, 3 minutes and 37 seconds. The second excerpt being from his body cam 3, starting from 9 seconds and going to 3 minutes and 49 seconds. I am going to request, Your Honor, that I just play these without sound for the purpose of what they're being admitted for.
Any objection?
No.
Okay. Go ahead and play those 2 clips. And this is Exhibit 5, if I remember. Maybe I'm wrong.
This is Exhibit 107, Judge.
107, I'm sorry. 107.
I'm just going to pause this right here at 3 seconds. Can you tell us where kind of you started from and where you're going, just so we can kind of get our wits about us here?
This is just as I enter into that living dining room area from the French doors. Those have been opened up, and now I'm entering into that area where in the upper left you can kind of see that couch where Derek Pedrin would sleep. That's where we're at.
And then what room are you walking into now?
I just entered into the kitchen. And then on the left-hand side of the screen there, you can kind of see the entrance to the basement stairs. That's right where that is. There's a little gray kind of covering there, or curtain, you can kind of see.
And for the record, I paused this at 27 seconds. Then what room are we in now?
Major's bedroom.
Paused at 1 minute, 19 seconds. I'll replay. So before we talk about the room that we're in right now, I'll note that we're at 2 minutes and 10 seconds. What was that area you just walked through?
That was the sleeping area for Araya, I believe, in Brantley.
And then what room are we in now?
Jaylen's.
Start again here. I'm going to pause here at 2 minutes and 47 seconds. And it may be hard to see if you can use the laser pointer. Is there something mounted above the wall, above the race car bed?
Yes, right up in here, there's actually a motion camera.
Where you pause that, Ms. Rude?
2 minutes and 47 seconds. Start again. End of the first clip, play the second. And then where are you looking at this point? Paused at 54 seconds.
I pulled back the red curtain and peering back into the other access to Josie Dikeman's bedroom.
And it has some items on top of it, but what is the piece of furniture we're looking right at?
I believe where the lamp is at is right adjacent to the left side of Josie Dikeman's bed.
Start here. Stopped at 1 minute and 20 seconds. What are we looking at now?
This is the entrance to reach the basement stairs.
Start. And are we now in the basement?
Correct, we're in the basement.
I paused at 1 minute and 48 seconds. What are we looking at in front of here?
There's a mattress on the floor with a sleeping bag on it.
Or you provided information as to whether or not anybody slept in the basement?
Section hearsay.
Sustain.
Continue. Investigative Sergeant, I think there's already been testimony that this may have been a difficult scene to process. Would you agree with that?
Yes.
And at some point, did you realize that there might be more to this investigation than just looking into an overdose?
At this point, we were looking at an overdose situation.
At what point did things change?
I think things started changing One, I had done the initial part of the scene and got Beth Lubinsky, the medical examiner, inside, and we started to examine Alexavier's body.
I want to go over some photos specific to the room that Alex was found in, and then we'll move into other parts of the home, okay?
Okay.
And Your Honor, pursuant to the pretrial stipulation, I'd like to move exhibits 83 to 106 into evidence. They're all photos of the home taken by law enforcement.
Any objection? So 83 to 106, did you say?
Correct.
No objection for the pretrial stipulation. I note that a couple of these appear to already be in evidence in our exhibits.
Okay, well, we'll receive them all, even if they're duplicates. Go ahead.
Thank you. Investigative Sergeant, look in exhibit 83.
The entrance from the front door into the residence.
And moving on to exhibit 84. What are we looking at here?
Standing inside Ms. Dikeman, looking out toward the front door.
Moving to exhibit 85, can you tell us what we're looking at here?
A dresser and television across from Ms. Dikeman's bed, be on the same wall as the front door.
And what about in 86?
The couch that was in Ms. Dikeman's bedroom to the left of her bed.
Would this have been the couch that Alex was seen on by Sergeant Kearney the night prior?
Yes.
Into exhibit 87, what are we looking at here?
It's just to the right of the couch. That's Josie Dikeman's bed. To the left of the bed is a white three-drawer cabinet. In the upper right of the photo, you can see the French doors then that lead to the.
And if you can tell, just move on actually to exhibit 88. What are we looking at here?
Those are prescription medications on a nightstand to the bed.
Moving to 89. What are we looking at here?
That's from the foot of Josie Dikeman's bed, looking towards the covered doorway.
And 90.
That's a closer shot to the left side of Josie's bed, the white three-drawer storage thing, nightstand or something similar to that left of it.
And can you show us in where the prescription bottles are that we exhibit?
Right here.
Moving to 91, is this just another view similar to one we've seen?
Correct. That's from the foot of Josie Dikeman's bed, focused more towards the back right corner of the bedroom.
And then in 92?
That picture on the left side of Josie Dikeman's bed, looking straight through the French door, open French doors into the living area.
Exhibit 3.
That's the covered body of Alexavier Pedrin.
Moving to 4. Yes.
Is a photo taken on top of Josie Dikeman's bed of the prescription pill bottle that Deputy Anderson and Jar had located when they arrived.
Moving to Exhibit 95.
That's a aerial shot of the open brown bag that contains various prescription medications that was identified by Deputy Anderson and Jar.
Is this the bag that was located near the body when law enforcement arrived?
Yes.
Moving on to Exhibit 96. Can you tell us what we're looking at here?
A top-down photograph of the bathtub with soiled underwear.
Did anyone, or did Ms. Dikeman inform Lieutenant Williams in her interview that Alex had had a toileting accident before police responded?
No.
She did talk about a stomach ache, correct?
Yes.
And reported vomiting to others?
I believe so, yes.
What are we looking at here at 97?
A top-down view, the toilet in the bathroom with some
Have we switched floor here in Exhibit 98?
that's the top of the stairs entering into the Araya and Brantley left, and then in the upper left shows, or I should say in the middle here, but the shows the camera.
Exhibit 99.
A closet area in that upstairs.
In your body camera, you showed or looked into some of those areas up there, correct? And is this one located right at the top of the stairs?
I believe so, yes.
Looks like it's got some children's toys and Pokemon cards in it.
Yes.
Ms. Dikeman reported to Lieutenant Williams that there's concern about Alex getting in.
I don't know that up.
Are you aware if that was something that was in the investigation?
Yes, it was.
Move to Exhibit 1 at here.
That's a jar of gummy melatonin.
And can you identify what that's a can of behind? And did Ms. Dikeman indicate in her conversations with law enforcement that she had given Alex and the night of the 10th?
Yes.
Moving to 1, do you know what room we're in here?
The kitchen.
And what are we looking at in this picture?
A box of that's Red Bull that you would get multiple containers in.
Moving to Exhibit 102, is there also a can of Red Bull?
Yes.
And then Exhibit 103, is there also a can of Red Bull located on the kitchen counter in this photo?
Yes.
Investigative Sergeant, I want to just take a moment to discuss a blue substance that was located when you were processing the scene. Do you know what I'm talking about?
Yes.
And is it fair to say the scene was also hard to process because of how the call originally started?
Yes, it was difficult because even in my initial briefing by Deputy Anderson, he said that a lot of stuff had been moved. He didn't recall what was on the bed or not on the bed because of moving items and throwing them on the bed to make room to work on Alex.
Typically, if you're processing a scene, it's helpful if things haven't been moved after law enforcement arrives. Would that be an accurate statement?
Correct.
And you did it, or while you're processing the scene, collect some fragments of blue substance, correct?
Yes.
Do you recall what you labeled that substance when you put it into evidence?
I believe I labeled it as unknown blue substance from the red pillow.
And in this particular investigation, were you the one who was oftentimes deciding how to label things for their submission into evidence?
Yes.
Did you have a discussion about the blue substance as you were processing the scene that day?
Yes.
And were you, again, wearing your body-worn camera during this portion of the investigation?
Yes.
And Your Honor, I would move for the admission of an excerpt of Investigative Sergeant Ammonson's body cam from body cam 1, a clip from 24 minutes, 53 seconds to 26 minutes, 23 seconds.
Again, that's exhibit.
It'll be on 107 as well, Your Honor. Thank you.
Any objection?
I think I know which clip she's referring to. No objection.
Okay.
Indicate for the record that it reverted to the still image.
Apologize. I will restart the video.
Yeah, and just
Whenever you're ready.
media, you may want to just use the audio in this. Obviously, there's Alex's body's in it. So.
Thank you, Judge.
You get this one?
substance, doesn't it?
It kind of does.
Looks like cotton candy, that's not.
The other thing I'm wondering.
I haven't seen a cotton candy bag.
So just a blue substance on the red pillow on the right-hand side of the bed.
Okay.
Can you explain for us what we just watched here?
What we were doing here, we're trying to process the area of the bed first because I know that we have to make more room for the medical examiner and her staff and us to examine Alex's body closer. So in processing that, I'm looking in this video that there was a blue flake of something on the pillow. I collect it, label it unknown blue substance, and then I'm starting to look down even further along the bed, and I start noticing more and more of this blue substance that it appeared to be sugary, like cotton candy or frosting, something similar to that.
And how many pieces of that did you recover from the pillow?
2.
And was that you measuring in the video?
Yes.
And was that, or who was taking photos?
Deputy Jar was taking photos, so it's good practice when you go to collect a piece of evidence that you have a photo taken just prior to that collection, and then the ruler was there for scale to show how big of a piece that substance was as well.
I think there's actually a comment made about no one or someone not seeing a cotton candy bag.
Yes, that comment was made by Deputy Anderson.
And when you were looking towards that area in the doorway, what were you specifically looking at there?
I was noticing more pieces and larger pieces of that blue substance, same color, same kind of texture around that area of the floor and further on.
If I can have the display again, please. We'll see how this works. I'm going to republish what's already been put into evidence as Exhibit 57 and published previously. Is this the blue substance, or can you point out the blue substance you were looking at in that video?
Right, it's a blue turquoise kind of color. So right here, there's some there, little piece there.
Did you find more of this substance throughout the house?
Yes.
Was it just located kind of in this immediate area?
No, the same substance. There's another bigger piece just inside the living room from the bedroom. There's also some on a stove, and then there's another piece that was even found outside on the deck.
Moving to Exhibit 104, what are we looking at here?
That's a Domino's pizza box on top of the stove. The front left burner also has what appears to be the same substance right here on the burner. Same color, same texture.
And I'm going to check you for color blindness. Can you tell me what colors are on that Domino's pizza box?
White, red, blue.
We will move on to Exhibit 105. Where are we in this photo?
That's on the back deck of the residence. You can see like a bucket used as a garbage can, a can of Red Bull, and then that same cotton candy-like substance.
And in Exhibit 106, what are we looking at here?
This is a picture of the kitchen and the kitchen counter.
And is there anything relevant in this photo to the blue substance?
Right, there's an empty container of cotton candy.
If I can have the Elmo quickly. Thank you. I'm going to republish Exhibit 239. Sergeant, do you recognize this photograph?
Yes,
And specifically, do you recall the blue substance on the pajama pants that we're looking at here?
yes,
Can you point out to where that is for the jury?
sure. This is the back right leg of the pajama pants that Alexavier Pedrin was wearing at his death.
And have you observed these pants in person?
Yes,
Is the substance on those pants that you just pointed out to also consistent with the other blue substance you were finding throughout the home?
yes.
If you're about to go to a different section, might be a good time for a break.
Sounds great, Judge.
Okay. All right. So we'll start back up at 1:15. If you need anything, let us know. Please don't talk about the case. We'll see you after lunch. You can step down. Anything we need to talk about, or can we just?
No, Your Honor.
Break? See you at 1:10.
Please rise.
Be seated, everyone.
Yeah, please. You have 3 minutes.
Yep, I'm going to have Rich testify.
Okay.
Judge, I've been having some computer issues. Can I have just 1 minute?
Yeah, go ahead. I'm waiting until you're ready. I'm waiting for you to be ready, so don't worry.
Don't start that, Dave. You have 4 hours left today. Don't start that now. Yeah.
Okay.
Those with yours. Make sure that all the together.
You mentioned something about. I can talk to him about it. Yes. Okay.
Ed, you need the audio jack too, or?
Looks like everybody is present. Just want to make sure you're ready. Hey,
Yes, Judge, thank you.
okay. Anything we need to talk about before we continue with the testimony from the state's perspective?
No, Your Honor.
Defense?
No, Your Honor.
All right, why don't you come up and take the stand?
Judge, one thing I'll put on the record is I talked to Ms. Rude, and I agreed that I won't object to her Exhibit 112 so long as it's clarified that Jalen and Major were residing in the home part-time during the time frame that they were designated on that chart.
I indicated that that's one of the questions I intend to ask Sergeant Ammonson, so we should be good to go.
Okay, so that hasn't been submitted yet, 112?
No.
Yeah, okay. All right, come on, have this in. We'll bring the jury in. Okay, everybody have a seat. We'll go ahead with the continued direct. Go ahead.
Thank you, Judge. Sergeant Amundson, did you identify and log the 4 medication bottles that Ms. Dikeman had next to her bed in the room where Alex was found deceased?
Yes.
And did you create a table in order to document the type and name and dose of those medications?
Yes.
If I can have you flip in your stack to Exhibit 108. You recognize this document?
Yes.
What is it?
That's the table for the medication next to the bed.
And is it a true and accurate reflection of what you saw in the home and documented that day?
Yes.
Your Honor, I would move Exhibit 108 into evidence and request to publish, please.
No objection.
Received.
Doing great after lunch. There we go. Is this what you documented?
Yes.
And I am not going to ask you to read the names of these medications, but none of these are Xanax or alprazolam, correct?
Correct.
And how did you identify the medication that was in the unlabeled bottle?
The medication had score marks on it. You can see where it says the name, the GG 335/100. You're able to look that up through a pharmaceutical resource to identify the drug.
And those other 3 medications were all in bottles that indicated they were prescribed to Ms. Dikeman?
Yes.
What about the medication in the 4th bottle?
There was no label on the bottle.
Were all of them sealed?
Yes, there was caps on them all.
Investigator, do you recall if the child safety locks were engaged?
I believe so, yes. They weren't flipped around for easy unscrew. You actually had to push down on a tab or push down on the top to be able to open it.
Did you also log and identify all the medication that was found in the bag near Alex?
Yes,
And did you also prepare a table that identified and listed those medications?
yes,
You turn to Exhibit 109. Do you recognize that document?
yes, I do.
What is it?
That is the tables for the medications found in the brown bag found adjacent to Alexavier.
And is it a true and accurate reflection of what you identified and logged that day?
Yes,
Your Honor, I'd move for the admission of Exhibit 109 and request publication.
Judge, I'm going to object to 18, lack of foundation for how that was identified.
18,
Number 18 on Exhibit 109.
okay.
I can ask a follow-up question, Judge.
Yeah, go ahead.
How was the medication in item number 18 identified when you were logging it into evidence?
by the score marks on it.
Tell me a little bit more about that process. How do you determine that with the score marks?
Well, each prescription drug has identifying information on it that you're able to look up through a pharmaceutical resource to see what the tablet or capsule is.
Is that something that when you are documenting evidence like this, you rely on customarily to identify medication if it's not in a properly labeled container?
Yes.
And does the information given to you when you check those score marks tell you both what the name and dosage of the medication is?
Yes.
Or I think that lays sufficient foundation. I realize you don't have a copy of this document in front of you, so you don't know what we're talking about. We can sidebar if necessary, though.
Judge, I guess I would ask if we could identify what this pharmaceutical resource was.
rxlist.com.
I didn't ask the question, so.
Okay.
Can you please identify the source you used to identify the medication?
rxlist.com.
Any objection now?
No.
Okay, it'll be received.
Can I publish, Your Honor?
Yes, go ahead.
Are these the medications that you identified in the bag?
Yes.
And were all of these medications sealed? Were there caps on?
No, number 18 was not in a prescription pill bottle.
Besides number 18, were all their caps on?
Yes.
Were the safety child locks engaged on those?
Except for the last one under 21, that bottle did not have a cap on it.
And when you say that the exception exists for number 18, can you explain that for us a little bit?
Yes. When I searched the contents of the bag, I pulled out each bottle individually, counted the number of pills compared to what the prescription label said, documented that, and then as I got down to the very end of that process, I located the 10 loose prescription pills for prednisone in the bottom of the bag.
Were there any other loose medications in the bottom of the bag?
No.
And did the both name of the medication and dosage of the medication match the name and dosage of the medication that was labeled on the bottle that was found next to Alex?
Yes.
And did the, strike that one, move. I'll ask that in a moment. Were all of the medications in that bag prescribed either to Ms. Dikeman or to Zayden Taylors?
except one, was either Josie Dikeman, I'm sorry, two, I couldn't determine. That would be number 8 and number 21.
Were all of the medications in the bottles, did they match what the label was for the medication?
Yes.
Sergeant, I am going to bring up some physical evidence to you.
I did find a typo here.
Please correct that for the record.
I'd have to refer to my report, but number 12, it says 22 of, and looks like we forgot to put that other number in.
But from your recollection, the number of pills or the type of pills matched the both dosage amount and the name for the medication?
Yes.
Were any of these medications either Xanax or alprazolam?
No.
Can you tell me what is located in the bag in front of you?
I refer to it by exhibit number.
I don't have one on it yet. I will in a moment.
This brown paper bag contains an evidence label. When I logged in, the Chaps brown bag containing RX pill bottles.
And is this the bag of medication that your team recovered on the 11th of February 2023?
Yes.
And was it packaged at the scene and logged into evidence?
Yes.
Has it been maintained in your or with your agency ever since?
Yes.
You have rules and protocols for how evidence is handled and if necessary transferred to a different agency for testing or something like that?
Yes.
I am going to bring up an exhibit sticker and mark it with exhibit 110. And Sergeant, is the condition and contents of this piece of evidence in the same general condition and an accurate reflection of what you collected on scene that day?
Yes.
Your Honor, I would move Exhibit 110 into evidence and ask that it be published to the jury. I think specifically certain items there, Judge. I don't know if you prefer to have him open it first and then we can go into that.
Can they publish all the items?
They can publish the items. I would like to have evidentiary protocol observed with glove changes between items that might contain forensic evidence.
Yep. All right. You want glove changes?
If we're handling multiple items that might be subject to forensic evidence testing.
Okay. What items are in there? Do we know what items are in there?
Yes, Your Honor, this is he read the Chaps bag with the medication inside of it.
So is it just a bag with all the medications in it?
That's correct.
I mean, if the goal is just to have the jury look inside of the bag, I'm fine with that so long as Sergeant Ammonson's wearing gloves. But like if we're going to be pulling out and moving evidence around, then I would like evidentiary practices observed.
There are 2 items I'll want taken out of the bag, Your Honor.
Okay. So we have gloves.
I have gloves.
You have gloves too?
Yeah, those won't fit me.
Oh,
Came prepared, Your Honor.
all right.
And Sergeant, if I can have you begin when you open the bag by taking out the 10 prednisone pills that you have identified as item number 12 on your table, please.
So, just so it's clear, it's being received, it'll be allowed to be published.
And are those the prednisone pills?
Yes.
Is there a separate evidence label on that package?
No.
And again, where were those pills located when you did your search of the residence?
In the bottom of this brown bag.
And those were the only pills that were loose in that bag?
Yes.
Can you, from your recollection, describe those pills?
I believe they are a round, peachy colored, chalky, uncoated tablet.
Sergeant Ammonson, can I have you open the top of that envelope and explain for the jury what you're seeing inside? I'll have you take a field trip in a minute with them, but.
I'm seeing the 10 round, peach, chalky kind of prednisone pills.
And when you describe them as chalky, what do you mean by that?
What I mean is that they don't have a good coating on them. Prescription drugs, some have better coatings than others.
Would it be best, Your Honor, to have him just walk in front of the jury to publish those?
I'd like to take a look at it first, just to make sure it's
Go
the same thing we're talking about.
Yes, I guess, I'm not sure you can put them in your hand or what, but, and then,
I think they're pretty visible inside of the evidence container.
okay. Oh, you could put them up to the Elmo. Does that make sense, or no?
I mean, if light's needed, certainly, willing to load my phone, or if you have a flashlight, we can do that.
Put them in his hand.
Yeah, no objection if he wants to put the.
Yeah. Still might be easier to put it under the Elmo with your hand, actually. I'm not sure. Go ahead, you show it to the jury if you want.
Go ahead and seal those.
That was was marked 112.
110. And then Sergeant Ammonson, can I please have you pull out the bottle of oxycodone that is labeled as being in that bag?
For the record, I'm observing Sergeant Ammonson changing gloves.
Excuse me.
I don't think I'll be able to identify that without removing the contents on how they're piled in there.
Without removing all the contents?
Correct.
Why don't we go ahead and have you line them up then? Are you okay with him?
So long as we identify on the record that all of the contents are being handled and then lined up and placed on an online surface in the courtroom here.
Okay. Pull them out, put them on the, I guess on the, just on the, right there.
And can you identify the bottle of oxycodone?
Yes.
Can you read the label on that bottle for me?
It's prescribed to Josie Dikeman, 505 North 7th Street, Brownsville, Minnesota. The prescription is oxycodone 5 milligram immediate release tabs. Take 1 tablet, 5 milligrams by mouth, every 4 hours as needed for pain for up to 14 days. The prescription number is 4822685-03498 with a quantity of 30, no refills, from Walgreens at 900 West Avenue South, La Crosse, Wisconsin, 54601, phone number 608-796-2058. Looks like the prescriber was Michael McCormick, PA, used before 5/17 of 22 and filled on 5/17 of 21. The description of the medicine is a round white tablet. Side 1 is scored M with brackets around the M. Side 2 is scored 05/52. May make you drowsy or dizzy. Do not drink alcohol with this drug. use care when operating a vehicle, vessel, or other machines. Taking more of this medication than recommended may cause serious breathing problems.
Thank you. I think given that you've emptied the bag, we don't need to have you do another Vanna White moment. So if you want to put those back in and package them up, I would be appreciative. Thank you.
So the evidentiary practices are observed in the record, Judge. The same pair of gloves was used. Same pair of gloves was used to both remove and place the medication bottles back into the bag. It appeared that something fell on the floor in the midst of that. The surface that Sergeant Ammonson had the pill bottles lined up on was the wood around the witness box. There was no sheet of evidence paper placed beneath it.
Go ahead.
Do you have another piece of evidence up there with you, Sergeant Ammonson?
Yes.
I'm going to bring you up an exhibit sticker. It'll be Exhibit 111. And can you please read the evidence label that's affixed to that package?
Prescription pill bottle for prednisone, empty.
Was this piece of evidence also something that you collected and processed as part of the search warrant on the 11th of February?
Yes.
And where was this piece of evidence located when you processed it?
When I collected it, it was on the right-hand side on top of Josie Dikeman's bed.
And it was also logged into evidence?
Yes.
And maintained in your agency's usual practice with items of evidence?
Yes.
And is it in the same general condition and an accurate reflection of what you collected during the search warrant?
Yes.
Your Honor, I would move Exhibit 111 into evidence.
No objection.
Received.
And before I have you publish this, Sergeant, can you please read the label on it? Actually, go ahead.
It would be easier out of the package.
That was going to be my question. Go ahead and do that. Your Honor, I can make a record about the reason why it should come out. For one, it's easier to read. The other is there have been some questions about the condition on the inside of the bottle. I think that's also easy for the jury to view if it's outside the evidence bag.
Now we also, the investigators lieutenant investigator, excuse me. No, putting on gloves. Go ahead. Any objection?
No, I'm late to the use of photographs if the state wanted to, if that's easier, but if we want, we can take it out.
Go ahead and take it out.
Okay, it's out.
Go ahead and read the label, please. Thank you.
Okay, this is prescribed to Josie Dikeman, 505 North 7th Street, Brownsville, Minnesota, then 55191607. Prednisone 20 milligram tablets. Take one tablet twice daily for 4 days, then one tablet daily for 4 days. Prescription number 4753215-03498. Quantity 12. No refills. Doctor authorization required. Walgreens at 900 West Avenue South, La Crosse, Wisconsin, 54601. Phone number 608-796-1000. 2058. Date 1/22 of 21. Used before 1/22 of 22. Aaron Zivney is the DO. It's described as a round peach tablet. Side 1 is scored 5443. Side 2 is scored DAN, space DAN. This medicine may lower your ability to fight off infections, avoid contact with people. I can't make that word out. Contagious disease, take with food or milk.
And is that score you just read consistent with the score of the pills that were located in the bottom of the bag?
Yes.
You mentioned not being able to read a word on the label. How would you describe the general condition of the label?
Worn, smudged and tattered.
Was prescribed in 2021, correct?
1/22 of 21.
And how would you describe the condition of the inside of the bottle?
Empty, with the same kind of chalky residue like I had on my glove when I opened up the envelope that had the 10 in there.
And when this was located, the top was off the bottle, correct?
Yes.
Your Honor, I asked that he be allowed to walk along the jury box again to publish.
No objection. I just want to take a quick look first.
Go ahead. Yeah, go ahead then.
Thank you. According to Ms. Dikeman's statement, this is a bag that had moved with her from Brownsville, Minnesota, correct?
Yes.
Fair to say that, you know, the medication in there, when you pick it up, can move pretty freely?
Yes.
Then those bottles are laying against lots of other medicine bottles as they're being carried or whatever is being done to transport it.
Yes.
And I believe you said you found the characteristic of the prednisone pills you published previously to be chalky, is that correct?
Yes.
Not capsules.
They are not capsules, they're pills.
And remind me again, the quantity of the prednisone pills that were found on the bottom of the bag was?
10.
And the quantity of pills on the label for the bottle found next to Alex's body was what number?
12.
Sergeant, when you were conducting the search warrant of the home, did you observe cameras in the home?
Yes.
And where did you observe those cameras to be?
I observed the camera in The second story, the one that was pointed out on where Zayden and Araya, not Zayden, I'm sorry, I misspoke, Brantley and Araya would be. And then there was another camera located in the kitchen on top of the kitchen cabinet, face down at a downward angle.
Did you collect anything related to those cameras on the 11th of February?
No, I had to climb up on top of the stool or something, I don't remember what I used, but to reach the other camera in the kitchen. I looked at it, and I did see a micro SD card, and then in the scheme of things of doing everything, I failed to collect it that day.
You did close the search warrant on the home that day, correct?
Yes.
And at the conclusion of that, was a decision made to have an autopsy done?
Yes.
Do you recall the date that was scheduled for?
That was Monday, February 13th.
Did you do any more investigative tasks yet that weekend?
Yes. On Sunday, February 12th, we arranged to have the forensic interviews done of children that were present.
On a Sunday?
Yes.
Why so quickly?
We felt it was important in this case to do the forensic interviews as quickly as possible to get the most accurate information from the children, to make sure there's no coaching. There was a protective plan put in place by CPS. And if this was if this didn't turn into a criminal matter, we wanted to make sure we could get those interviews done and back to the mother as quickly as possible as well.
Who had forensic interviews done on the 12th?
I believe that was Brantley and Araya and Major.
And were you present for those interviews?
Yes.
Were you present when the children were brought in for those interviews?
Yes.
Who brought in Brantley and Araya for their interviews?
Brantley and Araya were brought in by Ann Ehlers, their great aunt.
That would be Becky Ehler's sister.
Yes.
And who brought in Major?
Major was brought in by his grandmother, Cheryl Anderson.
Jalen was also living in the home at that time, correct?
I believe she was living there part-time, yes.
And was an interview of Jalen completed that weekend too?
It was not.
Do you know why?
She was not at the home at the time of Alex's death. She was staying with Becky Ehlers, her grandmother.
Was one eventually done?
Yes.
How much later did that happen?
I believe that occurred March 2nd or 3rd of 2023.
Did you try to have a forensic interview of Jalen done before that date?
We did.
Why didn't that happen?
There was some mental health concerns. There was some barriers dealing with Rebecca Ehlers, the grandmother, scheduling, so we had to work through those before we could get that done.
Eventually, though, by early March, Jalen was also interviewed?
Yes.
If I can have you, do you still have your exhibits in front of you?
I do.
Have you turn to Exhibit 112, please? Recognize this document?
I do.
And based on your knowledge of this investigation, do you have an understanding of the children involved in this case?
I do.
Does that include who their parents are?
Yes.
And generally where they were living in February of 2023?
Yes.
And are there indications on the document you're looking at as to whether or not a child listed was living with Derek and Josie at that time, February of 2023?
There's a star following their age.
Were Major Hellrude and Jalen Barnes living with Josie and Derek full-time in February of 2023?
No.
Your Honor, I would move for the admission of Exhibit 112 and request to publish.
No objection with that caveat.
Okay. Go ahead and publish. It's received and published.
Sergeant, can you describe here what we're looking at?
I think it's easy to start with the black boxes. So you have Josie, Derek, and Jenna. And then you can see the line going above Josie. Those are children that Josie has with no one listed in this case, or in this diagram. That's Zayden, who was 13 in 2023. Jaylyn, that was 10, only staying there part-time in 2023. Major, who was 8 and only staying there part-time in 2023. Then you have Josie and Derek with the points going down to Brantley, age 5, and Araya, age 4. Josie is the biological mother of those two, and Derek is the biological father of those two. Just to the right of that, you have Derek is the biological father, and Jenna Love is the biological mother of Aubrey, age 14 in 2023, and Alexavier, age 6 in 2023.
And Sergeant, are you aware where Aubrey was living in February of 2023?
I believe she was living with Cheryl Anderson, grandmother.
Did you attend the autopsy that was conducted on the 13th of February?
I did.
And after attending that, did you have a more expanded view of the condition of Alex's body at the time of his death?
I did.
What are your, or did that in any way shape what you did next, or your agency did next regarding this investigation?
Yes, after gathering initial and preliminary information from the autopsy, it was clear that this may not be a tragic accident and actually may be a criminal matter that we're going to have to look at further.
About that time, was a decision made to bring in the Department of Criminal Investigations to assist?
Yes, we did contact the Wisconsin Department of Justice Division of Criminal Investigation for assistance, knowing that this could be some type of homicide and we would have to use their resources.
How does that process work when an agency like yours wants that assistance?
Generally, a ranking officer, a ranking administrator would contact the Wisconsin Department of Justice. They would contact the special agent in charge for our region, advise them of what we have, the initial information of the investigation and what resources we're requesting to assist us.
And in this particular case, what kind of things did they assist with?
Well, first of all, they assisted with manpower. There were several special agents that helped us. Mike Haverly, Adam Fredrickson, Jay Greeno. We also had other agents out of the Eau Claire office that were used to help with digital forensics. There was an analyst that was assigned to help go through the mountains of digital information that we were able to get.
In a case like this, you described it as mountains of information. Can you elaborate a little bit more?
Sure. In these types of investigations, you have a lot of information coming in at you all at once. When you do search warrants for cell phones, if there's computers involved, if there's cell records, the school records even, all of these things can be man-hour intensive to go through. For example, my cell phone has a capacity of 256 gigabytes. The things that we hold in our hands can create reports that are thousands of pages long of activity, internet searches, keystrokes, text messages. There's just tens of thousands of pages of stuff.
So a lot of man hours to fully review that information you're receiving.
Yes.
Sergeant, was there a DNA submission made to the Wisconsin State Crime Lab?
Yes.
And what did that pertain to?
Could you repeat the question?
What did that relate to? What was that for?
Sure. The prednisone pill bottle that I just showed you was sent to the state crime lab for DNA analysis to see if Alexavier Pedrin's DNA was on touch DNA was on the pill bottle and cap. And
do you recall what date that was submitted?
We did it early in the investigation. It was February 24th of 2023. We had to wait for his DNA card to come back from Rochester before we could send it for comparison.
And why does it come back from Rochester?
The DNA card is prepared at the autopsy. Then they had to wait for that to dry and do their chain of custody. So that's when we got it, about the same time we got it back.
At the time that was sent in, did you have toxicology results back?
No.
And you mentioned wanting to see if Alex was a contributor. What does that mean?
Well, we wanted to gather that important piece of this investigation is whether Alexavier Pedrin's DNA was located on the cap of the prescription pill bottle or on the pill bottle itself. We felt that that was an important piece of information to know to help steer the investigation.
At some point, did your agency realize that Deputy Jar had given CPR to Alex ungloved?
Yes. One of the things we did do with this investigation is review the body camera of Deputy Anderson and Deputy Jar. We did that early on, especially after we had the Wisconsin Department of Justice on board, so they could see the scene and they could see what we saw, so they had all the information to conduct interviews and to assist us. That's when we quickly noticed that Deputy Jar did not have gloves on initially. He didn't put gloves on until a few minutes after starting the emergency effort.
By that time, had he touched both Alex and the prednisone bottle?
Yes, he had been doing CPR for quite a while on Alex, and then actually picked up the pill bottle and then picked up the cap with his bare hands and placed it on the bed where you saw the picture of it.
To be fair, in those early minutes of his response, what was Deputy Jar's priority?
Deputy Jar's priority was to, as a first responder, to provide emergency medical care to Alexavier and see if he could save his life.
After Deputy Jar handled that bottle, it was then put on the bed, correct?
Correct. It was put on the bed that was fitted with a blue bed sheet.
And that was a medication that had been prescribed to Josie Dikeman, correct?
Correct.
She had made statements that she had put those pills in the bag and was attempting to find a way to get rid of them, correct?
Yes, she did disclose that to Lieutenant Williams.
Derek also lived in that home?
Derek did live in the home, yes.
And before those toxicology results came back, you had no idea whether or not Alex had consumed prednisone, correct?
Correct.
Did the importance of those results related to your investigation change after you found out there was no prednisone in his system?
Yes.
Why is that?
Because it seemed like it was a stage scene then, gathered from the evidence that, starting with the condition of Alex's body when Deputy Jar first got there, to the administration of CPR and the substances that came out of Alex, the fact that this prednisone bottle would have at one time contained 12 medications, and 10 of those were found in the bottom of that brown bag, and the pill bottle was laying open adjacent to him.
So as you gain more information, some investigative function that seemed like a high priority when it was first done may lose priority. Is that fair to say?
That's fair.
Mentioned all that data that came in. Were there a lot of search warrants or subpoenas that were executed related to this case as well?
Yes, there was a lot of warrants that I was part of writing, plus we also had DCI agents writing.
And did some of those warrants relate to communication records for the parties involved in this case?
Yes.
Were those communication records just for Ms. Dikeman?
They were not.
Did your agency request through legal process Facebook records for both Derek and Ms. Dikeman?
Yes, for Derek Pedrin and Josie Dikeman.
What about legal process for Verizon records?
There were records requested for Derek Pedrin, Josie Dikeman, and then I believe it was Rafael Suarez or something similar to that.
And how is he connected to this case?
We had learned that he was texting with Josie Dikeman the night of February 10th into February 11th. We had to actually track down the phone number to identify him.
But at some point that happened?
Yes.
Did you also complete Google data search warrants for both Josie Dikeman and Derek Pedrin?
Yes.
And what about search warrants for Apple iCloud information?
For both Derek Pedrin and Josie Dikeman, we did the iCloud warrants.
And when you are requesting that kind of information, what kind of data are you looking for to help with your investigation?
You never know what data is going to be important. Google, for example, there's dozens of things that Google actually tracks, from internet searches being the most obvious to games to maps to locations. We try to gather all that and then kind of parse through that. The cell phone stuff has to deal with when calls are being made, incoming, outgoing times. So we're looking for everything that we can get.
Can help establish timelines.
It helps establish timelines. It helps establish when the phone is active, so we know that there's someone using it or not using it.
I want to go back to that time period right after the autopsy. Was there kind of a lot of activity in those next several days related to the investigation?
Yes, a lot of activity once the autopsy was complete.
Was Derek Pedrin formally interviewed on the 14th of February?
Yes,
And did you participate in that interview?
yes, Lieutenant Williams and I interviewed him.
Was Becky Ehlers also formally interviewed on the 14th of February?
Yes,
After that interview with Ms. Ehlers, was Mr. Pedrin interviewed again on the 21st of February?
yes, he was interviewed again on the 21st of February, 2023.
Through the course of your investigation, are you aware whether or not in that interview, Mr. Pedrin talked about going outside of normal discipline with Alex?
Yes, I believe that occurred. Investigator Leinfelder and Special Agent Frederick did that interview.
Was that the interview where he described his perspective of what had happened in the car in May of 2022?
Correct.
As those initial weeks passed, did some of the electronic information being collected begin to be analyzed?
Yes, so with the help with the Department of Justice, we created a share file. So as those files came in, they would be placed in there so their analysts and us would all have access to that. So as the Verizon warrant from Derek Pedrin came in, that was put in there. From Josie Dikeman, that was put in there so that we all had access.
And as you were receiving kind of the pertinent parts of that data collection, was that allowing you to conduct more interviews?
Yes, we were able to identify others that we wanted to speak to in this investigation.
Did you and Special Agent Mike Haverly meet with Lorelei Raines on March 1st of 2023?
Yes.
And at that point in time, what was her connection to this matter?
Lorelei Raines was talking with Josie Dikeman on February 10th in the evening hours. I believe it was after 9 p.m. We wanted to interview her and see what she knew.
Did you ask her about Rafael Suarez?
We did.
What was the purpose of that?
There was a number that we found in Josie Dikeman's Verizon records that was labeled ANFI worker, I believe. And that was who Rafael was, saved in her contacts as. And we wanted to know what Lorelei Raines knew about this in relation to Josie Dikeman.
Did you also ask Laura Lee about someone named Wayne?
Yes.
What was the basis of that?
Wayne Colkind had been identified as staying at Josie and Derek's residence.
Say move to strike.
Stay.
Its effect on the listener in terms of the investigation and what he did next, Your Honor.
Okay, then it's not being offered for the truth of the matter, but for the effect on the listener only. Okay, go ahead.
We had just learned that Wayne had stayed there occasionally in the basement.
And in terms of your investigation, why was having that information, following up on that information important?
To do a complete and thorough investigation, if you had something like that to follow up on, it's best to do so.
Were you trying to gather as much information about people who could have possibly been in the home during the time Alex was injured?
Yes.
At that point in your investigation, the information your department had from Ms. Dikeman was that Alex was asleep from 5 p.m. to 7 or 8 p.m. that day. Is that correct?
That's correct.
And police had made contact with the home for that welfare check that night of the 10th, correct?
Correct.
And that contact was shortly after 7 p.m.?
Yes.
Why were you seeking Mr. Pedrin's communication records related to this case?
Mr. Pedrin was not ruled out as a suspect. We were in the middle of the investigation, and it seemed pertinent that he would have access to Alexavier, as it's his son. We wanted to explore all options and everyone that lived in that house.
Were you also following up with other agencies or people in the area to kind of help determine that timeline related to Mr. Pedrin?
Yes.
Would that include verifying his work hours?
Yes, one of the special agents from the Wisconsin Department of Justice and another investigator went to Ship Shape Car Wash, conducted interviews there, as well as obtaining the time card for Derek Pedrin for the week before this incident.
But also, why follow-up was done with Walmart to verify the transaction or the timing of the transaction he completed on the 10th of February?
Yes, we were able to obtain video from Walmart loss prevention documenting Derek being at Walmart. We could see him inside and as he was leaving.
Sergeant, do you recall, or were you present and recall Attorney Zacher questioning Lieutenant Williams yesterday about the investigator speaking to Mr. Pedrin about what a defense attorney might say about Mr. Pedrin not providing his phone?
I recall that.
Do you recall the approximate time frame of when those investigators had that conversation with Mr. Pedrin?
I believe it was in September of 2023.
It wasn't in those early weeks of the investigation during those interviews with Mr. Pedrin?
No, it was not early like that.
It was after Ms. Dikeman had already been charged and through the preliminary hearing process?
Correct.
It was after kind of those mountains, as you described them, of data and communication information had been analyzed?
Yes.
It was after the final autopsy report was submitted?
Yes.
And it was after Mr. Pedrin recorded telephone calls with investigators listening in. Is that accurate?
That is accurate.
You were present when those calls were made, correct?
I was.
What was your role in that?
I was one of the investigators that was next to Derek Pedrin that you saw in the video, while I could only hear the one side of the conversation. That would be with Derek talking.
You reviewed those calls then in full after they were recorded?
Yes.
And those were recorded in March of 2023?
Yes.
Sergeant, you were also present when Attorney Zacher accused Mr. Pedrin of drinking or smelling like alcohol during his first day of testimony. Do you recall that?
I recall that.
Did you have an opportunity to get in close proximity to Mr. Pedrin after that accusation was laid, but while he was still on the witness stand?
Judge, I'm going to object to this. This was already deemed improper.
Yeah, I'm going to sustain the objection. I don't know if anything was done after, but I'm going to sustain that objection. Because it was, the question was asked, it was denied, we move forward.
Did you have any concerns related to Mr. Pedrin being under the influence of alcohol during either day he was testifying?
Objection.
No, overruled.
I did not have any concerns that Derek Pedrin was under the influence of alcohol, nor did I smell an odor of an intoxicant.
Sustained. That is stricken. There's There's no concerns, so that's the answer.
Mr. Zucker, want to stipulate to that?
No, the no concerns was his opinion about Mr. Pedrin at the time.
I'm going to take you back once more here, Sergeant, to the 14th of February, but this time on the topic of the second search warrant related to the cameras. Were you able to retrieve anything related to the cameras that was useful in your investigation?
No.
What did you discover when you went back for that second search warrant?
When I examined the cameras in the home during the first search warrant on February 11th of 2023, I noted the camera upstairs did not have a place to even put a micro SD card in. I did note that the camera in the kitchen and the camera on the exterior of the garage, those were Genie cameras, and there were micro SD cards in there. And I don't want to say chaos, but in the midst of all the things that we were trying to do, I did not pull those micro SD cards. So therefore, when we were going to have TRU come on the 14th to map out the house, we also were going to collect those micro SD cards at that time.
Why did you think that the information on those SD cards or the information related to those cameras could help in this investigation?
Well, we wanted to see if anything was on them. We have done some research to determine, for example, the camera upstairs was entirely cloud-based. It's encrypted files only being able to be seen by the person that has the app on their phone and in their specific account, so they couldn't provide anything. It's possible to back up some of those information on a micro SD card with the other two cameras, similar to what a lot of people have in their own home. Instead of paying for the subscription, you can get a number of days before it rewrites information.
So did you give up on that information at that point?
I did not. I was upset that the SD cards were gone, and I was trying to do whatever I could to get access.
So what did you do?
I then wrote search warrants to Yi Technologies, that's YI, and a search warrant to the Genie, so it's Mercury Genie company. And one of the responses I received was exactly what I just said, that the app on the phone is the only way to gain access to the video. It has to be through that subscriber, their email address and password. Mercury Genie also states that the only thing you can get is from the app, same way. You have to have it on your phone or log into your account. But additional video could be saved on the micro SD cards. So I tried to get it from both places.
Did you do anything next?
Yes. So then the decision was made to write a search warrant to assume the user's identity. So in this case, I wrote the warrant for the Yi camera system and the Genie system because we had the forensic download from Josie Dikeman's cell phone that contained usernames and passwords. So I was going to try to attempt to get the videos that way.
Did that work?
It didn't work as good as we hoped. With the Yi system, I downloaded the app to my work cell phone and tried to log in under Josie Dikeman's email address and password and was unsuccessful. The account was not there, which would lead me to believe that it had been deleted. I tried to do the same thing, log into the Genie app on my work cell phone, and I could not get into it. Then we did a third thing. The third thing was we actually took Josie Dikeman's phone out of evidence and hooked it to Wi-Fi, and we were able to get access to the cameras from the Genie app.
Did it go smoothly from there?
No.
You can just refer now to document or exhibit number 113 in front of you. You recognize the photos contained in this exhibit?
I do.
And do these relate to your attempt to get some of those cell phone or the videos from the interior, exterior of the home using Ms. Dikeman's cell phone?
Yes.
And why were you taking pictures as you went through this process?
We took pictures because we wanted to document what we were doing, to be able to show the steps that we took to gather this information and to preserve it in case it was ever deleted.
And are the pictures located as part of this exhibit fair and accurate representations of the documentation that you were doing throughout this process?
Yes.
Would they assist you in being able to describe what happened with this process to the jury?
Yes.
Your Honor, I'd move for the admission of Exhibit 113, request to publish.
Judge, if the state intends to use this as a basis of or foundation of knowledge for Investigator Ammonson to describe the inner workings of the Genie system and how data is or is not deleted, then I would object as lack of foundation, but if not, no objection.
Thought it was used for refreshing his recollection what he did.
Used to what he did and what he observed as he was doing this process, Judge.
Okay. As long as it's what he did and what he observed, that's fine.
We turn down the lights just a little. It might be easier. Investigator, you should have a copy of this in front of you. I don't know if that's easier for you to read from there. But can you tell us what we're looking at in the first photo here?
This was the login history to the Genie app.
And was this, why were you looking at this screen as you were going through this process?
I felt it was important to see if there had been any access to the Genie app since February 10th of 2023.
And what did this picture reflect to you when you were making that determination?
The third paragraph down on 217 states we noticed a new sign-in to your account on 217 at 5:31 p.m. from iPhone 12, 8. If it was not you, please change your password immediately.
And then what about the information in the top two paragraphs?
The second paragraph down, that was at 10:57, and on February 20th of 2023, I believe that was when we were trying to sign into the account at that time.
And then
the next one's at 11:52, and I believe that would have been the time we were trying to sign in with Josie Dikeman's phone.
So the two attempts at the top, you believe, were both by your agency in attempting to get this information?
Yes.
Okay. Were you able to log into Ms. Dikeman's account?
I was.
If you can turn to page 2 of Exhibit 113, what are we looking at here?
At the very top, it says driveway. And this is the camera view from the Genie camera mounted on the front of the garage at their residence.
And then moving to page 3, what about this photo?
This photo, so I was able to start to click into dates. And this one shows from the 19th of February. It says home, remove device at 8:42 and 42 seconds p.m. on the phone model iPhone SE, second generation. Josie Marie JZ at gmail.com removed the kitchen camera.
That would have been after your search warrant, correct?
No, that was before my search warrant.
That was a bad question, Sergeant. After the search warrants that you executed at the residence.
Yes, after the first search warrant on February 11th.
Moving on to page 4, what are we looking at here?
At the top, it says 20th February, and what you see of the second one down, that is actually where it says alert 11:55 and 24 seconds a.m. This would depict law enforcement, myself and Lieutenant Williams trying to log into the Genie app. So it shows that we've logged in on a new phone, the model iPhone 11. This was not done by you. Genie recommends changing your login password immediately to protect your account. Below that, it shows on February 19th again where the subscription was canceled because the device kitchen has been deleted, and we've canceled subscription of Genie Basic Plan yearly. The service will expire on 1/5/24. You will not be charged for the next period. That's from the 19th of February at 8:42 and 42 seconds p.m.
The login or the alert at 12:18, is that a device that you're familiar with?
No.
Not a law enforcement device? It wasn't you or somebody in or with your agency also trying to log into the phone?
No, we actually, when we were gathering the information from the 11:55 a.m. login, we were kicked out of the application by a different user.
Judge, I'm going to object to lack of foundation for the basis of that opinion.
Yeah, sustained.
So you were accessing data from this app, correct?
Yes.
How did that end?
It ended when we were removed from the screen that we had the data. It logged us out. And then we tried to log back in again and found that.
Okay. So after you found that message, were you still able to access the contents that you had previously seen within the app?
We started losing data. The February calendar had visible markings where there was data, that being photos and or videos. And after that, we were furiously trying to get more information from the 11th. Well, the 11th was already deleted when we logged in, but then other dates were vanishing in front of us. They were just being erased.
Were you able to log back into the app at that point?
No, we didn't get any more data after we lost all that.
From the data that was extracted from Ms. Dikeman's phone, were you able to determine what kind of views the cameras in the home provided?
Can you move the microphone down a little bit and repeat, please?
Sure can. I'm sorry. Thank you for that reminder. From the extraction that was done with Ms. Dikeman's or on Ms. Dikeman's phone, was there data contained in that extraction that allowed you to determine what kind of views the cameras inside the residence had?
I'd ask the state to specify a time frame for the views that the cameras had.
Well, in January and February of 2023.
I don't think I'm understanding your question right.
And that's my fault. Again, bad question. Do you have Exhibit 114 in front of you?
Yes.
And is this a extraction report related to Josie's iPhone 2?
It is.
And what does this extraction report contain?
The extraction report here contains some data files from the iPhone of Josie Dikeman.
And are these specifically related to photos that were located during the extraction?
Yes.
Is it a true and accurate copy of the photographs that were part of the extraction of her phone?
Yes.
Your Honor, I would move Exhibit 114 into evidence and request that we publish pages 2, 3, and 4 of that exhibit.
Subject to cross-examination.
Yeah. Be received, go ahead and publish.
Looking at page 2 of Exhibit 114, are you familiar with what we're looking at here?
Yes, on this side, I believe, is the curtain that goes into Josie Dikeman's bedroom. These are the stairs that go upstairs, and this would be this side of the kitchen.
And is there a logo on the bottom left portion of that photo?
Yes, it's spelled Y-I.
You know what that logo is for?
The Yeek camera system.
And that's one of the camera systems that you observed being in the home?
Yes.
And what is the date and timestamp of this image?
12/28/2022 at 03:04 and 27 seconds.
And does the contents of this image align with the camera positioning that you observed in the home?
No.
Was there a camera still there or in this position when you conducted the search warrants?
I don't recall.
But Yi cameras were something you were familiar with related to Ms. Dikeman's investigation?
Yes.
And can you explain for me or describe for the record the positioning of the curtain that seems to be hanging from the doorway to the dining room / Ms. Dikeman's room?
It is twisted, and I would say 3/4 of the way open with, it looks like part of the curtain is tucked into, I think, a handrail, which I don't see there, so it's held up by something.
But you can see into the interior of that room from the hallway?
Yes.
Moving on to page 3 of Exhibit 114, do you recognize what we're looking at here?
Yes.
the same general area as the previous picture?
Correct.
And what is the date and timestamp of this photo?
01/16/2023 at 01:32 and 21 seconds.
And again, if you can describe for me the location of the curtain that is hanging in the doorway.
The curtain is approximately 3/4 the way pulled up, twisted, and secured some manner to the right-hand side of the stairs.
And there's actually a different logo in the bottom left of this photo.
Yes.
Can you just identify that for the record?
Kami, Kami, all in lowercase letters.
And then moving on to page 4 of Exhibit 114, can you tell me what we're looking at here?
That appears to be the upstairs of the residence. In the area where Araya and Brantley were known to stay.
Appears to be above that race car bed, is that correct?
Yes, I believe that police car, the police bed or whatever kind of car it was, with the blue there, you can see it in the bottom of the photo.
And does this position of the camera seem to be consistent with the camera that you saw while executing the search warrant in the residence?
Yes.
You can then turn your attention, Sergeant, to Exhibit 115. Is this another extraction report from Ms. Dikeman's cell phone download?
Yes, it is.
And is it a true and accurate representation of data that was collected from her iPhone related to the extraction done on the 13th of February 2023?
Yes.
Your Honor, I would move for the admission of Exhibit 114, request to publish page 2 of that exhibit.
Ooh, 115.
Yes, Your Honor, thank you.
115. Any?
Cross.
Okay, yeah, received, can publish.
And Sergeant, what are we looking at in this photo?
It appears to be a screenshot from 750. There's an arrow facing left, says playback. There's a date and time stamp on the genie area of the photo, and it says 02-10-2023 at 07:31 and 31 seconds p.m.
And is there a logo on this screenshot?
Yes, it's got the genie logo.
And was this the approximate time that police had contact with the residents on the 10th of February?
Yes.
We're going to move on to something different now, Sergeant. If I can have you please look at Exhibit 116.
Judge, can I get a sidebar on this?
Okay.
Sergeant, are you looking at Exhibit 116?
I am.
And can you please identify this document?
This is an attendance summary broken into two categories, one for the 2021-2022 school year and the other for the 2022-2023 school year.
And was this document compiled with the information that was contained in the business records provided by the school district related to the children's attendance?
Yes.
Do the days absent break them out into unexcused and excused absences?
Yes.
They do? That was a trick question, probably. And I apologize for that bad question.
I'm looking at different.
Your Honor, can I move for the admission of it and ask to publish, and then I think we can talk through the exhibit.
Okay.
But can we get a clarification on that answer? That was the trick question before?
I will stipulate that it includes both excused and unexcused absences, Your Honor.
Okay. It has both excused and unexcused absences. You can go ahead and publish.
Thank you.
From the earlier discussion we had.
Does it indicate for the 2021 to 2022 school year at the top there that there are 170 or were 175 days of school in that year?
Yes.
And I think we heard testimony, but fair to say in that 2021 to 2022 school year, we were still in COVID protocols?
Yes.
How many days absent was Alex in kindergarten of that year?
Well, 42.
And what about Major, who was in second grade?
24.
And Jalen, who was in fourth grade?
29.
And there are some additional remote learning and absent family days included in this chart, correct?
Correct.
Related to the 2022 to 2023 school year, as of the date of Alex's passing, does this indicate that there were 101 days of school that year?
Yes.
And how many days had Alex, who was in grade 1 that year, missed?
40.
And do you recall that about approximately 5 of those days were related to the broken femur?
That sounds right.
Okay. And what about Brantley, who was in kindergarten that year?
29.
And Major, who was in third grade?
22.
And Jalen, who was in fifth grade?
27.
We've talked about that communication data being pretty dense. Is that correct? Is that a fair term?
I'm sorry, could you repeat the question?
Yes, we talked about the communication data that was collected in this case as being pretty dense. Is that a fair representation?
Yes, there's a lot of data.
So when you're using those tools, can it be hard to produce the results in a way that may be easy for an end user to review?
Yes, it can be complex.
And has there been a lot of review of the data related to this case?
Yes, by a lot of people.
Is it also part of the process that you have to identify how each person uses different forms of communication, whether that be text or social media?
Yes.
If I can have you give you a new set of documents here.
Can I just get a clarification? So in that chart, you're saying that 20, just so it's clear, there was an objection on the excused, unexcused, the 22, 23 chart includes both excused and unexcused absences? Is that what you were saying?
Correct, Your Honor. It's total absences.
It's total absences, whether excused or unexcused?
Yes.
Okay, thank you.
We're gonna need a sidebar on 117 too.
No, okay, come on up in 117. There we go. Yeah, if you want to go take a break. I'm just going to take a look. Give me a second to look at what we got to. Just for right now. Yep. How many, no, let's go back on the record. I'm going to go on the record here. I just want to ask it, how many days are we talking about of information that are here?
You mean how many instances, Judge?
Yeah, I guess not days, but like exchanges is really, I guess, the question.
Five, Your Honor.
And these exchanges were all part of discovery?
Absolutely, Your Honor. They're also within the time of the charging period in this case.
Okay. Is the intention to go through each one of these pages?
The intention, Your Honor, and that's why I provide the summary, is that I provide the data from the cell phone extraction so that they have that and they can verify it with their own records, which is helpful, I think, when we're doing summaries, especially with how the statute's written. And then the summary pages that are in the much easier to read tables would be what I would publish to the jury. It's a summary and that's the date and the time, but it's made easier for everybody to digest so that we can get through it much more quickly. And so
it looks like there's at least 117, 118 through 125. Is that right? Okay.
yeah, that I thought you were speaking specifically, Your Honor, to 117. There's also timeline information from the phones related to the 10th and the 11th that I intended to get into as well.
We might as well address all. Is there a summary on these other packets?
No, Judge. If there's not a summary, it's my intention to just ask Sergeant Ammonson about specific instances in those. I provide the bigger part of the exhibit just so, again, Attorney Zacher and the defense team have the context of things, and so the whole record's provided.
Okay.
That's the issue, Judge.
All right. So really, we're only talking about 117 here is the issue. 118, I don't know if you have an objection, 118 through 125. Those look like packets of information that was, It looks like 126 and 127, 128. Is that correct?
Yeah, 125 is a summary document of 124, again, so that it's easier to read. The other issue that I think we were struggling with when Attorney Zacher was presenting Facebook images or messages, Your Honor, is that it's in the universal time code, and so we're saying things like subtract about 5 or 6 hours wherever we are with daylight savings, and I think that's confusing to the jury and to the witness. And so not all of these are exhibits that I intend to publish, but it is information that I intend to go through.
Mr. Zacher?
Well, Judge, the problem here is that these are documents that were altered and generated by the state for the purpose of production at trial. A statement of or Sergeant Ammonson here.
What statement?
You're offering these as his statements.
I'm offering them as exhibits that are coming in through him, just like the
exhibits that are coming in through him that have been altered by the state and presented as evidence.
They're Ms. Dikeman statements.
It was not presented to us before trial, Judge. This is a discovery violation. 971-23-1, parent A out. A relevant recorded statement of any witness on the state's list. It also contains evidence of other acts that were never introduced or litigated, despite the fact that we have a motion in limine agreeing that the state would not be introducing other acts unless they were pre-litigated, particularly incidents where the state is attempting to paint Ms. Dikeman as a pill distributor or somebody who was receiving pills unrelated to this case. Oxycodone, or whether or not she got pain medications from her mother after Mr. Pedrin beat her, mind you, are not relevant at all. Like, show me how this is admissible under Sullivan. The statements themselves that the state is also going to be introducing, it's hearsay. We've got statements from Becky Ehlers, we've got statements from Mr. Pedrin. I haven't been able to cross-examine or confront either of them. This is far too little too late. It should be excluded.
What exactly is the information that Attorney Zacher didn't have prior to today, Your Honor? If he looks at these summaries, and you're allowed to produce a summary as long as the entire record is available to defense counsel so that they can verify the accuracy of the summary, that's allowable. This is all information he has. It's in a form so the jury can digest it.
And I don't know, my objection was the same to Exhibit 116, which grossly misrepresented the number of days that Alexavier was out of school with excuses.
Doesn't matter for truancy. The school keeps track of it the same way.
All right. Let me ask this question. The parts which are not the summaries, are those accurate? Are those things you had?
We have these records, Judge, but I disagree that either the summary or the in particular some of the content of this summary is even admissible. I think that this is unnoticed other acts. It serves no relevant purpose. It's dramatically outweighed by the prejudice to Ms. Dikeman, tending to paint her as a drug addict or somebody who procures pills when this was never litigated once before trial.
Your Honor, it also goes to the other acts that they are putting at Mr. Pedrin, right? We saw all those videos where he's like, you use pills. She's like, no, you do, right? The jury is allowed to have information to determine whether or not those other acts were proved to the necessary standard. There, again, is nothing in these statements, these summaries that they didn't previously have. It's within the time charge period, or the charged period here, Your Honor.
The state should have noticed this as another act and brought it up with Mr. Pedrin while I could confront him on the stand about those statements.
I can't. They're not his statements. He wasn't involved in these messages between Ms. Ehlers and Ms. Dikeman. Your Honor, her attorneys are representing, right, her as somebody who successfully completed drug court, and especially in comparison to the evidence that they presented regarding Mr. Pedrin. Like,
she did successfully complete drug court, Judge. And
wait, just give me a second, okay? God's sake. So the problem I see is this, is I don't know what they're referring to in these things. I don't know, 10 pills, 3 pills, whatever it might be. It's not clear what they're referring to.
Prescription pills.
No, I understand that.
Okay.
I understand it's prescription pills, but the reality is it Xanax? Is it oxycodone? What is it? Because I assume it's for pain medications or vice versa.
Attorney
Xanax is
Zacher, excuse me, Your Honor, but Attorney Zacher said, I believe in his opening statement, that she was getting these pills from her mom because she was being hurt.
yeah.
So he's acknowledging, right, that they know what kind of pills they are. I mean, I know we can't drag this out, Your Honor. I know that, but if I understand.
I was told yesterday that, no, our direct, it won't take that long. We're more worried about Mr. Zacher's. Right now, Mr. Zacher's not going to be starting until about 3:30, 4 o'clock at best. And the state has taken all day. So I'm going to give you a choice. One, you can use 1 or 2 of the, I actually think 117 looks like that's related to those pills. I get that. The other ones, are you objecting to 118, 117? Damn it.
Yeah, and Your Honor, the first one on 117 already came in, the comment about getting Xanax, so.
And Judge, I agree that's probably relevant context evidence, that text about the Xanax. Where my objection lies is all these texts about, well, oxycodone or anything else.
Attorney Zacher represented she's getting it because she's being hurt by Mr. Pedrin. What she's representing to her mom in these is that she has different ailments, and it isn't for that purpose, Your Honor. So I think it goes to her credibility as well.
Talked about the hydrocodone texts that were recent to the allegation. I didn't talk about anything else.
They're all in the time period that these charges were contained in the criminal complaint.
Just a second. I'm going through these summaries. I don't even see the word oxycodone. I don't see. I'm just going through your summaries, right? That's what was actually said in these.
Judge, people who are trading medicines don't put the kind of medicine they're buying in this, right? We had this script text related to Mr. Pedrin.
So, but then it's pure speculation about what the actual drugs are, right? We don't know what the drugs are because this is, except for the Xanax response. But the rest of them are, do you have 9? Do you have 2? Do you have 10? Are you going to the pharmacy? I mean, you're giving me about 4 minutes here to review this, so if I'm misquoting it, I'm sorry, but.
I don't think he has a proper legal objection to this, except he doesn't like it.
I've stated my itemized objections repeatedly.
Yeah, that this is a discovery issue. This should have been turned over, so
Judge,
we're not
how is
going
it a discovery issue? I would like a ruling on that because, Your Honor, I have other messages. We're going to have a cross-examination next week. I would just like.
We're going to have cross-examination next week?
Judge, what do you?
All right, Dahlia, I'm going to take about a 5-minute break. Let me think about this. I don't even know. To be honest, yeah, give me a 5-minute break, okay? Let me think about how this should go.
And then we're cross-examining witnesses next week.
seated. Okay, first of all, on the issue of 117, 117 is a summary of exchanges it looks like it's mostly Becky Ellers. Is it all Becky Ellers, I think? Exchanges with Becky Ellers. The statements by Becky Ellers are hearsay. First of all, on the issue of discovery, this was turned over. I do believe the state has the ability to make a summary. The problem I see more is the issue of hearsay in these. You know, they're not being offered for the truth of the matter, but there are statements that are being stated by Ms. Dikeman, which are being offered for the truth of the matter to prove that she's involved with getting certain types of drugs from her mother, and these are prescription, they seem to be prescription drugs, to be honest, and not highly things. So this is what I'll let you do. I'm not going to let you use the summaries. I'll let you use that. You can say the dates and the times of what Josie Dikeman said in these to avoid the hearsay situation. That's what the current situation is. Because I think otherwise Ms. Ellers should have been able to testify as to what she said.
Then Judge, we can call her. Is that
Right.
what you would prefer? I think her statements give context. I would note that.
They're not being offered for the truth of the matter, right?
Absolutely, Judge, just like.
But there's a whole, like January 19th, there's one phrase by Ms. Dikeman. The rest are responses by Ms. Ellers. So you cannot be offering the last three because it's the effect on the listener question, right? Did this listener, this is not being offered, it's giving context for this.
Your Honor, but.
Just have 1 second with Ms. Ruder.
Yeah, go ahead.
Your Honor, about the 19th, I hear what you're saying. I think, though, the context actually comes from the messages a week later where Ms. Dikeman says, Mom, do you have a couple more extra I could buy? I'm not doing good with this COVID. Right? And both times, it's Mr. Pedrin going to get the medicine. I would note the one that's around the May date, Your Honor, coincides with the prescription label of the oxycodone that Sergeant Ammonson testified to today. So I think that also gives context to that. I didn't put all of them in, Your Honor, that were within these records. I tried to be selective.
No, I mean, I understand you're trying to be selective, et cetera, but you have hearsay here. You're trying to tell me it's being offered for contextual reasons, but you're not calling Ms. Ellers to bring this on with Ms. Ellers. But, you know, I think that's the problem with this, that these are exchanges between Ms. Dikeman and Ms. Ellers, and yet I understand you're trying to speed it up with the investigator, but it seems to me that this is if you want to get into what the content is by Ms. Ellers, you got to have Ms. Ellers testify to it.
Then, Judge, will you strike the testimony related to Mr. Pedrin and the script and the unknown person that they provided that evidence related to?
There's no objection at the time. It was a valid hearsay, except not tit for tat when it comes to these. I made the objection, the state did not.
I'm seeing what I have in front of me right now. I'm not.
I know, but I understand what something not being offered for the truth of the matter means. So that's my frustration, Your Honor.
Judge,
And I think the objection was made at that time, Your Honor, and it was said that it wasn't for the truth of the matter asserted. Context.
Okay. 117, you can use Ms. Dikeman's quotes. You can use the what I will allow them to be is you can say, you can have Investigator Ammonson talk about what was said right before it and then what was said. So there are some that sort of an exchange back and forth. But there's a whole nother series where, I mean, the very last one in theory is about a vape. It's not even about drugs.
No, Your Honor, that is Ms. Ehlers asking that Derek pick up the vape on the way to pick up the pills because she's at work and she needs her vape.
That seems a lot built into that statement. I'm sorry, but
I am too,
text messages are laden with, you know, we don't know exactly what was said. That's why hearsay becomes a lot more difficult to start adding and applying inferences to what it's being said here. People have inferences being said, and they could be wrong. It's speculation as far as I'm concerned. I mean, actually, that last exchange, she talks about a vape. She doesn't talk, at the very end, she talks about a vape. She doesn't talk about pills.
Ms. Ehlers talks about the vape being brought to her.
Right. I mean, I don't know. Okay.
Judge, I would note that this packet contains exhibits marked through 128. My objection is the same to all of these proposed exhibits.
Well, 118 looks like, this is just a Cellbrite, from what I can tell. That's
All Cellbrite or Facebook data.
Okay, so but this is not, it's just a section taken out, right?
What is, Your Honor?
The Cellbrite, 118 is Cellbrite data that was taken out of the discovery.
Correct.
Or out of what you got back on the search warrants. Or from the, actually not a search warrant, but it's from the download.
I'll save this, Rob. No objection to 118.
What about 121? I don't know where 119 is. I may have misplaced it.
I don't have a 119 in here.
Okay. 121 looks like to be the same thing. Is that correct?
Well,
it's
all Cellbrite information. They contain different parts of the Cellbrite data, Your Honor.
Right. So 121, let's go through this so we don't keep on having continuous objections. So 121, 122, and 123 seems to be Cellbrite data. Is that correct?
Yes.
It's Cellbrite data, but looking at 121, it's a complete mix. So we've got web search history, we've got call logs, we've got instant messages, we've got text messages. It's still rife with hearsay. It's rife with irrelevant content.
I'm not offering all of it, Your Honor. I offer these when I give them to counsel prior to me beginning questioning, so they have a minute to look at that. I like to pre-mark things and be prepared so that we can hopefully move through things more quickly. I provide these for the context.
Hold on.
I know. So there are certain things I'm going to go into on each of these exhibits. I'm not going into everything on them.
So 124 looks like Meta Platform business records. So that's another, that came probably from a search warrant of some sort. It's 125 that seems to be, is that some type of composite log? Or is that from Meta Platform records?
125 is a summary of the meta information in 124.
Okay.
And again, part of the reason for that is so that it has the accurate time frame when the witness is testifying to it.
Right, that's correct. I see that. And do you have an objection to that?
Judge, more than half of this is hearsay from Mr. Pedrin.
Were you going to go through each one of these
No, Judge.
exchanges?
And we would be here for a whole nother week. That wasn't my intent. Again, I do this so they have context, so that I'm not presenting one message, out of a million messages, and then they're scrambling, and it's taking us time to get through this stuff. So I provide all of them in context so that we can get through this if they have questions.
So is your intention to show what Mr. Pedrin is saying? Or just what Ms. Dikeman?
No, Your Honor. My intention is to show what Ms. Dikeman is saying. Sometimes it includes a statement of Mr. Pedrin, like if she's answering a question related to what I'm getting into with this exhibit. But it's, again, offered for context and not for the truth of the matter.
So 124, 125, there might be a selective objection on hearsay, but I'll take a look at the context. Those are admissible. Then 21, 26, and 127. Or is it just 126? This is the exchange between Ms. Raines and Ms. Dikeman, which has been essentially.
That 127, no objection.
That summary?
126, no objection.
Okay, 126 and 127. What about 128?
Again, as a summary of what I intend with my further direct of the sergeant to get in. So it's just providing context of the evidence that comes in. Because, right, the problem is I have to present it in these piecemeal ways because some of it comes from Meta, some of it comes from Cellbrite, that sort of thing. I'm just trying to put it in context for the jury.
I'm just trying to figure out. So 128, there are statements from Raphael, I forget it, but there's statements back to him from Ms. Dikeman, and then there's the call to 911. There's the call to her mother, called 911. I think that is contextual, but what was actually being said by Mr. forgetting his name? What's his last name?
Suarez Porfirio.
Suarez. Okay, I'm sorry. I mean, do you object to any of that in 128?
Judge,
Technically hearsay.
if I had been emailed this a week ago,
Let's just tell me, do you object to it?
I don't know if it's accurate. I have to object at this point.
Right.
And Your Honor, if I have to change these exhibits, that's the other part. I can't do that on the fly at this point.
I'm not changing. What I'm saying is I'm okay with 128. Yeah, I mean, I think 128 is the context of what happened right in that morning, so I don't have a problem with that at all. So what I'll say is for 117, so we're going to have to break it down because I don't know what else other way to deal with this. Is July 6th, I don't have a problem with that entire being submitted. July 11th, that's fine.
May 11th, Judge?
What?
The May 11th?
May 11th, 21, that's fine. October 10th, I think do not use October 10th, but you can do the first three exchanges that can just be read. Read by, what were the exchanges? 105, 115, 115. Do you see what I'm saying? This first three? Because that's contextual, yes, what's up, and then she answers. What Ms. Ellers says afterwards is hearsay.
Can I ask a clarifying question?
No, are you following what I'm saying or not?
I am. I was just wondering if we could ask based on the context of the conversation, what was it about without putting in those other statements? Could the investigator say that on that particular dialogue?
I think it's up to, unless Ms. Ellers is here, that context doesn't, you can give this to the jury and the jury can decide if it's really relevant to drug dealing or not. Even if I let Ms. Ellers put in what she says here is, I will get home, I have your 20, I have 10 extra, I'm now at Walmart, or I'm at Walmart now, where are you? You know, probably about medications, but the reality is unless Ms. Ellers is here to explain what that exchange is about, I'm not sure how that is, or as Ms. Dikeman explains it. So whatever the investigator says is that it's conjecture. It's not based in what he knows about what was actually what was meant or said, because it is hearsay. It's why hearsay is excluded, in fact. So the next exchange, January 19th, I believe, is what I was on, 2023. How are you feeling? Throat hurts and back hurts. Ms. Dikeman doesn't even respond. She just says, my throat hurts and back hurts. So, unless I'm missing something.
That's the one I said was in context, where she a week later then asks if she has a couple more that she can buy.
So a week.
Says I can give you 10, and she said Derek went to pick up the kids so he can stop by you.
That's connecting something that happened in January 19th, 2023 to January 26th, 2023, 7 days later. You're saying that my throat hurts and back hurts is the reason why 7 days later this other thing is exchanged?
I'm saying it puts in context, right? When she's saying I'm calling for a refill now, it's ready, but I work until 9. I can't get it till tomorrow, but I can give Derek a couple to try. So she can't give him a lot. She has a couple because she can't get a refill till the next day.
You're making a lot of assumptions that the couple that she's starting to talk about 7 days later is the same couple she's talking about 7 days before.
She's asking for a couple more.
Couple more what? Unless you have the person saying, this is why hearsay is...
I understand, Josh.
Yeah. So you know what? I just don't... I'm not going to allow 19th and 26th. You can bring in the other ones as I've explained. We've already talked about the other ones. So, all right, let's go forward.
Hold on, Judge. I want to make extra certain. Are you saying I can publish the summaries for both July 6th of 2021,
July 6th of 2021,
May 11th of 2021?
May 11th of 21. It's only part of October 10th of 22.
I'm going to skip that one, Judge. We're just going to keep moving.
Okay, and I think 19th, no, and the next one, no. So it's only those two.
Judge, just so I don't interrupt the flow, I'm just going to enter a standing hearsay and confrontation and speculation and relevance objection to the remaining content, and I won't object individually.
Yeah, I don't think this is a discovery issue. I think it's more of an issue of hearsay issues and then confrontation, but I think the way I've limited that, that avoids those issues. So, all right, let's get going, bring the jury in. We'll figure it out after. I don't think it's 126. Go ahead and bring him in. You can come on up. Investigator, you can come on up. Oh. All right, everybody may be seated. So just to assure you, we will be done by 4:30 today. Okay. All right, go ahead.
Investigator, in your review of Ms. Dikeman's cell phone download, did you review some messages between Ms. Dikeman and her mother, Becky Ehlers?
Yes,
Are you looking at Exhibit 117?
I am.
Specifically related to page 1 and 2 of that exhibit, is page 3 related to that exhibit a fair and accurate summary of the Cellbrite data?
Yes,
And then is page 4 another portion of the Cellbrite extraction related to a conversation that Ms. Dikeman had with her mother, Becky Ehlers?
yes,
And was that conversation in May of 2021?
yes,
You can turn to page 5 of that exhibit. Is a summary contained on that page, a fair and accurate summary of the Cellbrite data contained on page 4?
yes,
Your Honor, I'd move for the admission of the pages of Exhibit 117 that I have just reviewed with Sergeant Ammonson, and then I would request permission to publish page 3 of the exhibit related to July 6, 2021, as well as page 5 of the exhibit related to May 11th, 2021.
All right, per the conversation we had earlier, court's going to allow it to be received. I understand there's an ongoing objection. Go ahead.
Sergeant, can you please read to the jury what this summary depicts?
July 6th of 2021, at 6:52 p.m., Becky Ehlers sends a message. I feel like I have ruined Jalen's birthday. At 7 p.m., Josie Dikeman replies, "No, it's okay. I've been rough on them too. It will be fine. We'll do her crab legs and cake." At 7 p.m., Josie Dikeman again says, "I got her some things she wanted from Walmart." At 11:28 p.m., Josie Dikeman sends, "Do you want to try a Xanax?"
I'm going to move now to page 5 of this exhibit. Can you please tell the jury what's depicted in this portion of the exhibit?
May 11th of 2021, 12:52 p.m., Becky Ehlers sends, "This sucks," S-U-X. At 1:28 p.m., Josie Dikeman sends, "I'm picking up mine. I have 30 and can get a refill in 4 days after surgery." 1:29 p.m., Becky Ehlers sends, "I don't want yours." At 1:33 p.m., Josie Dikeman sends, "If you don't calm it, it won't get better."
Thank you, Sergeant. If I can have you turn now to Exhibit 124. Can you please tell me what we're looking at here?
This is Meta Platforms business record, page 160 through page 180.
Are these specifically messages between Derek Pedrin and Josie Dikeman?
Yes.
And is the dates related to these messages February 7th of 2023 through the 10th of February 2023?
Yes.
If I can have you then turn to Exhibit 125. Is this a summary of the Meta Platforms Facebook records that were contained in Exhibit 124?
Yes.
And does the time related to the messages in the summary convert the time from the UTC timestamp to the Central Standard Time timestamp?
Yes.
Your Honor, I would move for the admission of Exhibit 124 and 125. It's not my intent to publish this, but to go through specific lines. I have numbered the lines on the summary, so it's easy for everybody to know what specifically I'm talking about before Sergeant Ammonson goes into the testimony.
Go ahead, will be received, ongoing objection.
Thank you. Sergeant Ammonson, can you please relate to the jury what the message is on line 6 of the summary exhibit 125?
It's from February 7th of 2023 at 3:17 and 26 seconds p.m. The sender is Josie Dikeman, and it states we should be following the no contact.
And as we've discussed, or has been testified to, that time period between the 7th of February and the 10th of February, was that between the two dates of Mr. Pedrin's arrest in February of 2023?
Yes.
And to be clear, Sergeant, if Derek Pedrin has a no contact with Josie Dikeman, whose responsibility is it to make sure that he doesn't have contact with Ms. Dikeman?
Could you repeat the question?
Yes. If Mr. Pedrin has a no contact condition of his bond, whose responsibility is it to make sure that he abides by that no contact?
Mr. Pedrin.
Is Ms. Dikeman under any obligation to abide by that court ruling?
No.
If you can please then read for us lines 9 and 10 of Exhibit 125.
February 7th, 2023 at 3:27 and 7 seconds p.m., Derek Pedrin messages Josie Dikeman, "Can I call you yet?" ?
And then what does line 10 read?
Line 10, February 7th, 2023 at 3:27 and 23 seconds p.m., Josie Dikeman responds, "Yes."
Can you then proceed to lines 17 through 19, Sergeant?
On February 7th of 2023 at 7:25 and 33 seconds p.m., Derek Pedrin messages Josie Dikeman, "I really miss you. My chest hurts." On February 7th of 2023 at 7:25 and 46 seconds p.m., Josie Dikeman responds, "Putting kids to bed." February 7th of 2023 at 7:25 and 51 seconds p.m., Josie Dikeman sends Derek Pedrin, "I miss you too."
You can then move to line 31, Sergeant.
February 7th of 2023 at 7:49 and 3 seconds p.m., Josie Dikeman messages Derek Pedrin, "I'll call you when I get them all down."
And then finally, the last message from the 7th, I'll ask you to read. Can you please tell us what the message in line 51 indicates?
You said 51?
Correct.
February 7th, 2023 at 9:03 and 58 seconds p.m., Josie Dikeman messages Derek Pedrin, "I'm going to put my phone on the charger and get some sleep. Good night, babe."
Sergeant Ammonson, Mr. Pedrin was released from jail on the 7th of February, correct?
I believe so, yes.
And it was Ms. Dikeman's statement that he returned immediately to the home. Is that correct?
I'm not sure, but I believe so.
Okay. And these messages seem to indicate that they may be having contact, but they're not in the same location. Is that a fair representation?
Correct, they're at different locations.
If I can have you then move to page 3 and read lines 127 and 128 of this exhibit.
February 8th of 2023 at 4:22 and 59 seconds p.m., Derek Pedrin messages Josie Dikeman, "I hope you have a good night."
And then what is line 128?
February 8th of 2023 at 5:16 p.m., or 5:16 and 32 second p.m., Josie Dikeman messages Derek Pedrin, "Are you staying at your mom's tonight?"
So there it seems that there's still some uncertainty about whether or not he'll be returning to the home. Is that correct?
Correct.
No, you're probably buried under a pile of paper there, Sergeant, but if I can have you find Exhibit 121, please.
Got it.
This report, another portion of the Cellbrite data that came from Josie Dikeman's iPhone with the extraction date of February 13th, 2023.
Yes.
Does this data encompass the dates of February 10th to, if you flip to the last page, February 11th of 2023?
Yes.
Does it contain call log, instant message, searched items, web history, voicemail, and image information data that was contained in her being Miss Dikeman's phone extraction?
Yes.
Your Honor, I'd move for the admission of Exhibit 121. Again, I will not publish, but I will be asking Sergeant Ammonson about specific numbered items.
Will be received with noting the same objections.
Sergeant Ammonson, can you please flip to page 5 and tell me what line 70 indicates?
Which line?
70.
70 is web history dated February 10th, 2023 at 12:05 and 42 seconds p.m. The source is Safari, and it says ambient oral, uses, side effects, interactions, pictures, warnings and dosing, WebMD.
Sergeant Ammonson, are you aware if Ms. Dikeman had a active prescription for Ambien?
I did not see that she had an active prescription for Ambien.
Have you then flipped to page 12, item 165? Can you tell us what this portion of the record indicates?
It's search items dated February 10th, 2023 at 2:54 and 35 seconds p.m. The source is Safari. It's for Domino's.
And if I can have you flip to page 180, or excuse me, page 13, item 181, and tell me what this record or portion of the record indicates.
It's from her call log. It's an outgoing call. February 10th, 2023 at 4:17 and 32 seconds p.m. to telephone number 1-608-779-3030, and the call lasted for 2 minutes and 45 seconds.
And Sergeant, through your involvement of this investigation, are you aware that that phone number is for Domino's Pizza?
Yes.
I can have you then flip to page 17, section 224. Can you tell us what we're looking at in this portion of the record?
It's a call log. Incoming phone call dated February 10th, 2023 at 7:22 and 37 seconds p.m. The call is from phone number 1-608. 2 minutes and 13 seconds.
If I can have you then turn to page 19, specifically line 257, and tell us what we're looking at here, investigator.
You said line 257?
Correct.
This is an instant message. It's outgoing from the cell phone, dated February 10th, 2023 at 9:07 and 11 seconds p.m. From 1-608.
Person who maybe doesn't want to make calls.
If you want to just say who it's to, that's fine.
It says it's to the AFNI worker.
And in the course of your investigation, did you identify that person?
Yes.
And who is that?
Rafael Suarez Portfolios, something similar like that. I probably butchered the name. The message, the instant message reads, "Now waiting for kids to leave."
And Judge, I'm going to try to get us through this faster, so if Attorney Zacher has an objection to how I'm going to introduce this next message, I can revert to what we're doing. But Sergeant, in the next line, 258, is that another message from Ms. Dikeman to Raphael stating that the two oldest are going with my mom tonight?
Yes.
Can I just time frame? Just give the time.
Oh, I apologize, Your Honor. And that was at 9:07 and 11 seconds p.m., correct?
36
36 seconds.
Oh, I apologize, 36 seconds. Is that correct?
Yes.
I am going to let you read the next one again. If you can turn to page 21 and tell us what is in, or the content of the information at line 275.
It's an instant message outgoing dated February 10th of 2023 at 9:21 and 19 seconds p.m. from Josie Dikeman to the AFNI worker stating, "No, my mom just got done with work and picked them up."
So according to Ms. Dikeman's statement here, by 9:21 p.m. approximately, the children who were going with her mom that night had been picked up. Is that correct?
Yes.
We will go now to page 34, line 445, please.
Can you repeat the line number?
Absolutely, 445.
This is a call log outgoing dated February 11th of 2023 at 9:21 and 40 seconds a.m. To mom, and it lasted for 52 seconds.
And you know Ms. Dikeman's mom to be Becky Ehlers, is that correct?
Yes.
Can you then go to line 446?
This is a call log. It is outgoing from February 11th, 2023 at 9:25 and 51 seconds a.m. to 911 for 4 minutes and 28 seconds.
Thank you. The best part of your job, right?
Yes.
If I can have you now go to exhibit 122.
Could you repeat the number?
122. Is this Celebrate extraction specifically related to the instant messages between Ms. Dikeman and Raphael on the date of February 10th, 2023?
Yes.
And on the first page of this document, does it indicate how many messages go between Ms. Dikeman and Raphael in this time period?
106.
And can you indicate by referring to line 1 what time the first message is sent?
Sure. The first message is sent on February 10th, 2023 at 6:18 and 53 seconds p.m.
You can then turn to page 10 and referring to line 105, tell us what time the last message in this time period was sent or received.
February 10th, 2023 at 11:44 and 55 seconds p.m.
Your Honor, I'm not sure if I moved for the admission of 122, but I would do that.
Okay. Received with the same objections. If there were objections, I can't remember on that one.
Now referring to Exhibit 123, is this the portion of the Cellbrite extraction related to Ms. Dikeman's instant messages with Raphael on the 11th of February 2023?
Yes.
And does it indicate at the top on the timeline how many messages there are in this record?
58.
And is this a true and accurate record of the data that was provided in the Cellbrite extraction?
Yes.
Your Honor, I'd move for the admission of Exhibit 123.
Be received.
Sergeant, between can you indicate, I'm going to have you turn to line 44. Can you indicate what time that message is sent or received?
It's an instant message, which is outgoing from Josie Dikeman's phone, February 11th, 2023 at 1:55 and 22 seconds a.m.
At 28 seconds a.m.?
Line 44?
49, I apologize.
Oh, I'm sorry. It's a line 48. It's an incoming instant message, February 11th, 2023 at 1:57 and 3 seconds a.m.
And then line 44 has a timestamp of 1:57 and 28 seconds. Is that correct?
Line 44.
49.
49. Yes.
And then is there a long break in the messages between message 49 and message 50?
Yes.
So does this record reflect that between midnight and the 11th of February and 1:57 and 28 seconds on the 11th of February, represented by message 40, there were 49 messages back and forth?
Yes.
And then if you can refer to line 50 and tell us what the specific content of that line is, including what the message was.
It's an instant message which is incoming to Josie Dikeman's phone on February 11th, 2023 at 9:17 and 29 seconds a.m. from Raphael stating, "Good morning, pretty."
Does Ms. Dikeman then respond in message 51?
Yes.
And can you tell us the time of that message and what she says?
February 11th, 2023, Josie Dikeman responds at 9:20 and 25 seconds a.m. "Good morning. Don't come yet. I have an emergency with my son."
Can you tell us the time and the content of the message she then sends in line 52?
In line 52, February 11th, 2023, at 9:20 and 35 seconds a.m., Josie Dikeman sends to Raphael, "I'm sorry, honey, hold on."
Have you then moved to line 54? Is that a incoming message from Raphael?
Yes.
And can you please give us the timestamp of that and what the content is?
9:31 and 12 seconds a.m. "Did something bad happen to your son? Question mark.
And then does Ms. Dikeman respond in line 55?
Yes.
Can you give us the content of that response and the time of it?
9:50 and 48 seconds a.m., Josie Dikeman responds, yes, he just died in his sleep.
Going to move on now to Exhibit 126, Sergeant. Is this a Meta Platforms business record related to Facebook messages between Ms. Dikeman and Laura Lee at that time, Rains?
Yes.
Is this a accurate reflection of the data that your investigative agency received regarding these messages and this data?
Yes.
Your Honor, I move for the admission of Exhibit 126.
Without objection.
Received. What? That will need to be 126A.
My favorite thing to do.
Yep.
I can then have you look at Exhibit 127. Is this a summary of the content contained in Exhibit 126?
Yes.
And is it a fair and accurate summary of the communication records that were contained in 126?
Yes.
Your Honor, I would move for the admission of Exhibit 127, request to publish.
Go ahead and publish. It'll be received too.
Thank you, Judge. Ready when you are. Investigator, can you please read for the jury the messages that are depicted in this exhibit?
At 8:24 a.m., Laura Lee Rains sends to Josie Dikeman, look what I found for Naomi. At 9:06 a.m., Josie Dikeman replies, that's cute. At 9:35 a.m., Laura Lee Rains replies back to Josie Dikeman, great for a sensory. At 12:35 p.m., Laura Lee Rains sends to Josie Dikeman, how did this happen? He was fine last night.
Investigator, we'll move on to Exhibit 128, please. Sergeant, sorry, now I'm...
It's fine, doesn't matter.
Can you please identify what we're looking at here?
This is a communication timeline between Laura Lee Rains, Josie Dikeman, and Raphael Jose. All right, I'm sorry, I misspoke there. So it's a communication timeline where you have Raphael, Josie Dikeman, Laura Lee Rains, Becky Ehlers, and 911.
And does it represent the period of time between 8:24 and 31 seconds and 9:50 and 48 seconds in the morning related to February 11th, 2023?
Yes.
And does this summary reflect the communication data that we just went through with great detail?
Yes.
Is it a fair and accurate representation of both what your testimony was and what the underlying exhibits demonstrated?
Yes.
Your Honor, I'd move for the admission of 128 and request to publish it.
Yeah, received.
And then just briefly, I don't think we need to go into the content of the messages, Sergeant, but can you relay the times and the nature of the content for each of these lines?
The first two lines are reference the conversation between Laura Lee and Josie Dikeman that I spoke about between 8:24 and 9:06 a.m. There's the 9:17 message from Raphael to Josie Dikeman, along with her response at 9:20 and 7 seconds back to Raphael with the emergency. 9:20 and 35 seconds, she messages him again just to hold on. 9:21, Josie Dikeman calls her mother, Rebecca Ehlers, and talks for 52 seconds. Then roughly 4 minutes and 11 seconds at 9:25:51, Josie Dikeman calls 911, is on the phone for 4 minutes and 28 seconds. Raphael communicates with Josie Dikeman at 9:31. Did something bad happen to your son? Josie Dikeman responds to that message at 9:50 a.m., saying, yes, he just died in his sleep.
Yeah. Sergeant, something I failed to bring up a few exhibits back is, do you recall the messages related to Ms. Dikeman and her mother dated May 11th of 2021?
I would have to get my memory refreshed on that.
I want to look at Exhibit 117, that should still be in front of you, page 5.
I have that exhibit now.
And specifically, Ms. Dikeman says, I'm picking up mine. I have 30 and can get a refill in 4 days after surgery. Is that an accurate representation of what the content of that is?
Yes.
And do you recall, investigator, when you were publishing the exhibit related to the CHAPS bag and the medication inside of it?
Yes.
And do you recall looking at the label of the oxycodone in that bag?
Yes.
You recall the approximate time period that prescription was issued to Ms. Dikeman?
I believe it was May 2021.
I can have you turn now, we're going to go back in time again a little bit to Exhibit 118, please.
Which number, please?
118.
Okay.
Can you tell me what we're looking at here?
This is a Celebrite extraction report from Josie Dikeman's iPhone.
And what times or dates does this include in this portion of the extraction?
From 1/16 of 2023 at 8:05 p.m. through 1/16 of 2023 to 8:18 p.m.
And does this specifically relate to searched items?
Correct.
Is it a fair and accurate representation of the data that was extracted from Ms. Dikeman's phone?
Yes.
Your Honor, I would move for the admission of Exhibit 118.
Received.
Sergeant, if you can just go through and tell us for each line the time of the search and then the description of the search.
Sure. All of these searches, the source is Safari. And 8:05, 23 seconds p.m., Josie Dikeman searched battered child syndrome. At 8:15 and 20 seconds p.m., the search for ED evaluation. 8:17 and 16 seconds, the search was code status, full code. At 8:18 and 20 seconds, the search was for code status DNR. At 8:18 and 46 seconds p.m., code status with a capital D. At 8:18 and 46 seconds p.m., code status DNR/DNI.
And Sergeant, are you aware of what was occurring in Ms. Dikeman's life during the period of time she was making these searches on the 16th of January, 2023?
I believe that was the time frame that Alexavier Pedrin was at Gunderson Hospital.
Your Honor, I still do have, I think, too much to push through today.
Okay.
I can be as brief as possible on Monday, but I think we should let everybody rest.
All right. So we will conclude for today. I should never say what I hope would happen, but we will get things done as soon as we can next, starting Monday, and then we'll go to the other side of the case. So again, like I said last Friday, if it's possible, try to forget about things, do something enjoyable, get away from this for a bit. If you need something, you let us know. My hope is to have some more treats for you next week, by the way. But have a good weekend. Don't talk about anything. Don't try to look anything up. If you happen to see it, try just to move on. Much national news. Just kidding. But try to relax. And again, thank you so much. It's been a long 2 weeks. A little bit more to go, 2/3 there. So we'll go from there. All right. We'll see you on Monday. Same time, 8:30. We'll talk about that.
Should be a box out there too.
Yeah, we'll talk about that. All right, you can step down. Everybody have a seat. We'll start up 8:30 Monday morning. Do have witnesses ready. We're going to try to go by the afternoon, hopefully.
Yeah, we'll see. I don't know how much longer the state has with Sergeant Ammonson. I'm obviously going to have some cross-examination for him.
Right. So I would expect if we're going to have defense witnesses, we'd start in the afternoon is my hope. If there's a way to shorten things up, I'd appreciate it. In the end, actually, I'll just say this, maybe I'm wrong, but in the end, that actually went relatively quickly through what we finally decided. I don't think that much was excluded. Is there anything the state wants to bring to my attention?
Judge, the only thing I would ask the defense to get back to me on is the pathologist that they're bringing in, the defense expert pathologist. In their original notice, they said that they were blaming both Mr. Pedrin and someone they identified as child number 1. I don't believe they ever pursued that in a Denny, but I just want to be prepared about what this pathologist is going to testify to in the underlying factual basis for his opinion. So I'd ask Attorney Bowles to get back to me on. I don't think there's any other acts being brought in regarding a child either. So
I think there's certainly some context evidence that might come in to explain some of these injuries regarding child number 1, but we only brought the Denny with respect to Mr. Pedrin.
all right, we can address that next week, but
Okay.
And Judge, on that note, I informed the state that Dr. Christensen's flying in from Salt Lake City for Wednesday, and it's my understanding the state is agreeing that we can drop what we're doing with whatever witness happens to be on the stand to get Dr. Christensen back to his flight.
Yeah, so he's flying in Wednesday and fly out on Wednesday.
Yeah, he's flying in on Tuesday evening, but we're hoping to do him Wednesday morning.
Right, okay. Yeah, well, let's,
It's their case, I'm fine with that.
yeah. Okay, anything else from the state?
No.
Make sure we have all the exhibits from the state, anything from the defense tonight.
Yeah, we have some exhibits over here. Judge, just to reiterate on the record, I maintain the same objections with the content that was just introduced, but I didn't object individually to save us time.
Yeah, I mean, I tried to say that the same objections. The only thing is I didn't say it when I thought they didn't apply, but yeah, I assumed you would have piped up and said. If what I'll say is that what we talked about in the break, the objections you lodged were continuing, I understand. And so if there's any question about why you didn't raise it again when it brought up again, for the record to be clear, you were following what I was suggesting, that you had objections, they were continuing objections, as you said. State have any objection to how that was done?
No, it saved time, is
Yeah.
expedient.
Yeah. So,
Okay.
if we need it clear in the record, that's what was.
No, yeah, I just wanted to ensure that it was clear on the record.
Yeah, no, I understand. Okay, having said that, enjoy your weekends best you can. We will see you back here at 8:30. I do buy the jurors some treats from a bakery once or twice a week, so that's what the reference was.
That's awesome.
All right. So, take care. Thank you.
The bakery inside or outside of Lacrosse, Judge?
Linda's.
Meringue.
Oh,
Oh, right. Oh, I was gonna say, like,